Blue G40. Unmuted. What's your name?
She's not connected to audio, Your Honor. I've been sending her messages in the chat, but I'm not sure if she can see them.
Callers. All right. Attorney Saman. Attorney Saman, good morning.
Good morning.
Good morning.
Okay.
People are here but aren't really here. Is Tommy Ron here? Tommy Ron? Anybody representing JL Transmission?
Not here.
You represent JL Transmission?
No.
Okay, what's your name, ma'am?
I'm Celeste Brinkley.
You're Celeste Brinkley, and do you? Okay. And I see Rosalind Frazier is here. Do you have an attorney, Ms. Brinkley?
I'm sorry, I didn't hear you.
Yeah. Do you have an attorney?
No. This is I'm the plaintiff, and my tenant's on the line.
Yes, Ms. Frazier, do you have an attorney?
No.
Well, to speak, do you all have a resolution?
Yes, she's paid.
Okay, so would you like to dismiss this case, Ms. Brinkley?
Yes, sir.
Okay, calling case number 2334-6781. This is Celeste Brinkley versus Rosalind Frazier. Can you state your name for the record, Ms. Brinkley? And then after that, Frazier, can you state your name?
Celeste Brinkley.
Thank you.
Rosalind Frazier. Oh,
Thank you.
Rosalind Frazier.
And good morning to both of you all. Ms. Brinkley, are you requesting that the court dismiss this case without prejudice?
Yes, sir.
Okay, this matter is dismissed without prejudice. Without prejudice just means that you can bring the case again in the event that you wanted to. So, Ms. Frazier, this matter is dismissed.
Yes, sir.
Okay, all right, well, you all are free to go. You'll get a dismissal in the mail, Ms. Frazier. Ms. Brinkley, are you submitting a dismissal or do you want the court to submit it?
I'll say that one more time, sir. I'm sorry.
Are you submitting a dismissal form or would you like the court?
Just dismiss it. They can just dismiss
Okay.
it.
Okay.
Okay. Is it possible, Judge? Is it possible you can give me that case number one more time?
This is 2334-6781.
Thank you. Perfect. Thank you so much.
You're welcome. You all have a great day.
Bye-bye.
Thank you.
Hello? No, Daddy.
Good morning. Blue G40, can you hear us? Put your hand up if you can hear us.
I'm still chatting her. I think she finally saw the chats, but she's not connected to audio.
Okay. All right, let's see, let's call a few more names.
Okay. Correct.
It's Callie Logan is.
How did you file?
Gil Madison here?
I mean, it just depends on.
Yes, Miss Madison is here and in a breakout room with legal aid.
Okay. Oh, yeah, okay. Thank you.
Do you have the case number?
Is Mario Brown here? Or Manna Knee-Block? All right, let's see, 178.
What did I tell you?
Does anyone live at 3063 Park?
No,
Does anybody live at 3063 Park?
you're supposed to be forgot. I'm trying to see.
Hello?
Anyone have? Hello, good morning. What's your name?
I don't know why you didn't receive a note.
Alan Yancey.
All right, I have you checked in. You're with Attorney Saman.
Correct.
Okay, yeah.
Excuse
I can't
me,
hear you.
Your Honor.
Do you have attorney, Mr. Yancey?
Hello?
Yes, Mr. Yancey, do you have an attorney?
I don't.
Okay, are you requesting an attorney?
Do I need an attorney?
I don't know.
No.
I don't know.
No, I don't think I need an attorney.
Okay. All right, well, when Mr. Saman is done with speaking to one of the other tenants, I'll let him know you're here and I'll invite you into a breakout room to speak with him. All right?
Yeah, I'd like to talk to him. Thank you so much.
You're welcome. And then it's *6 to mute, *6 to unmute.
Okay, *6 to mute and *6 to unmute. Okay.
All right. And Samsung with the hairstyle like mine, sitting on the couch. What's your name? With the gray shirt.
He looks like he's
Yeah,
trying to talk into a microphone and it's not working.
Yeah, that mic is not.
I'm trying to unmute. How do I unmute?
No, you're unmuted. You're unmuted, sir. Good morning.
Good morning.
What is your name?
Azikwe Robinson. It's spelled Azikiwe. My last name is Robinson.
All right. What time is your match?
I didn't hear you.
What time is your court
10
matter?
a.m.
10 o'clock. Yeah.
Okay, and do you have an attorney?
No, I don't. I had spoke. No, I don't.
Okay, do you want an attorney?
Well, I had spoke with my landlord and she said she would give me 2 more weeks.
Okay, is Kyra Morgan here? I know you're scheduled for 10 a.m. So we have you checked in, Mr. Robinson. Sit tight for a minute. If you want an attorney, this will be the time to talk to them. If you think you have and you can handle it with your landlord or you all have an agreement, that's up to you. So,
Well, I would take she's not been bad on me, so I would take the possibility. She said she would give me 2 more weeks, and I believe that I could. I'm trying to get it all worked out in these 2 weeks.
all right, we'll see if you all can work something out, and then if not, we'll have a hearing and we'll figure it out. So either way, we have you checked in. And Attorney Sean.
Ready, Your Honor.
What matter are you on this morning?
Covering for Elaine Marderosian on ends in 709.
Okay, is Indiana Green here? Indiana? Is this a dismissal, counsel?
No, Your Honor.
Okay. Is Miss Green here? Indiana Green. Okay, I'll call defaults an hour after the scheduled hearing, so you have about 15 minutes and I can recall this case.
Thank you.
You're welcome. Morning, Ms. Lamonius.
Good morning, Your Honor.
Is Ms. Baker here?
Ms. Baker is here. She just checked in. I did get a chance. This is with Attorney Cox. I'm going to be leaving soon to go back into Judge Brew's courtroom. But I did speak with Attorney Horka, and I am here on behalf of Ms. Baker, who is in the gallery. And I'll be back once I hear back from Attorney Horka.
Okay, all right, sounds good. All right, is Counsel Montgomery here? Counsel. Dave Smith. Dave Smith, looks like Dave.
Yes,
Good morning, Mr. Smith.
I'm here on behalf of Mr. Smith, Your Honor.
Thank you, Ms. Namaz, and good morning.
Good morning, Your Honor.
Attorney Saman has, looks like 1 or 2 is working on. Attorney Saman, good morning.
Saman?
Now, I'm looking for him too, Mr. Yancey.
Okay, I'm sorry.
No, it's all right. It's all right. Don't worry about it. That means you're listening. Attorney Goodwin.
Good morning, Your Honor. I believe Attorney Horker and I are ready on the matter ending in 5102.
5102. Is Daniel all right?
Yes, Your Honor.
All right, let's do this. Mr. Harker here.
I'm on the record, but we're just
I'm here, Your Honor.
Okay, I'll give you just let me know. Let me know when you're ready. So just keep your hand up, Mr. Goodwin, and then we'll call it as soon as he's back. And Carmen's iPhone.
Yes, I'm here. My name is Carmen Davis. I'm not sure what time or if I was leaving today or tomorrow, and I don't have my case number.
Uh-oh, Ms. Davis. We'll see. Okay, Carmen Davis. I'll see you on the docket today.
You got a school bag on. My buddy, a whole bag. Is it possible it's the 26th instead of the 25th?
2, 3, 3, 4. Let's see. Hold on 1 second. It's today at 1:30. Sure.
It's in front of Judge Brew.
It's in front of Judge.
That's that one anyway.
What? Let's see. Well, you have 2 cases right now?
Yes. This is for 205 Orleans.
205 Orleans.
No. So, yep.
Okay, so I think we found it. Just give us a second.
I'm sorry, I didn't hear you.
One second. Let's see.
In front of Judge Brew.
You're in front of Judge Brew at 1:30 today. So do you have Judge Brew's code, Zoom code?
Yeah, when I was in Judge Brew's room, she told me to come to your room. So go back to her at 1:30.
Yeah, go back to her at 1:30. It doesn't look like it's transferred to my courtroom.
Okay, you said tomorrow or today?
Today.
Okay, thank you so much.
You're welcome. And if you have any issues, you can pop back in, but the clerk just checked it out and it looks like you're still with Judge Brew. So just let me know if you have any issues. We'll be here for a minute.
Okay, thank you.
You're welcome. Is Alice Hill here?
Yes, Your
Alice
Honor.
Hill?
Yes, Your Honor.
Okay.
She's in the breakout room. I too am trying to find Attorney Simon to discuss this case. We have a resolution,
Okay.
but I've been unable to get his attention.
I'm here if you'd like to invite me.
All right.
Terrific.
Well,
I will invite you into a breakout room.
he's got Alan Yancey before you, counsel. Well,
Okay.
and then he's on the phone. So after Mr. Yancey, I would say, talk to Mr. Lon, just so, because people on the phone don't know what's going on. They can't see what's going on. Unless you have a tight docket, Mr. Lon, I'll let you do what you need to do, but.
I am with you all day, Your Honor.
All right, okay. Let's see, Mr. Samar, I'm gonna put you in the breakout room with, Mr. Yancey.
Sure.
Okay, and then I'll leave it up to you after that, but I wanna get him, situated because he's on the phone and I don't want him to drop off.
Thank you, Your Honor.
No problem.
I think room 15, is that it? Okay, all right, let's call this case, calling case number 2334-5102, Emerald Springs Apartments versus Danielle Wright.
Good morning, Joe. Work at P75969 to be at the plaintiff.
Good morning, Your Honor. Keith Goodwin, PA 3997 on behalf of Ms. Wright, who's also in the courtroom as well.
All right, Ms. Wright. Good morning. Did you state your name for the record? I couldn't tell.
Danielle Wright.
Thank you, Ms. Wright, and good morning.
Good morning.
This we have here.
All right. But Your Honor, on this matter, so we'd be requesting an adjournment until May 31st. Balance is currently at around $638. Right now, Ms. Wright did actually make a substantial payment for 614 yesterday, but I'm informed that they haven't confirmed payments yet. So we'd just be asking for a very short adjournment to May 31st in order for those payments to be confirmed and to make sure she finishes paying off the rest of the small chunk of the rest of the balance, and then so then the case could be dismissed at that time.
Okay, and May 31st makes sense. So we can get this. Ms. Wright,
Yes.
I mean, you're almost at the finish line, so I'll see you back May 31st. What time is good?
Your Honor, this same time works on May 31st.
Okay, let's do 9 a.m. May 31st, and just know, what's your monthly rent? Ms. Wright?
156.
Well, 156 is coming around the corner of June 1st. So just, I'm not required, you're not required to pay that in this hearing because we'll be back May 31st, but just know that it's right around the corner. That's just a practical step. But good luck, and you're almost done with satisfying this balance. So just get this done, but know that June rent is due as well.
Okay.
Just not on this judgment. Just keep that in mind. But
Okay.
I'll see you back 31st, and it seems like you're on your way to closing this case. Let's get it closed on May 31st.
Okay.
All right, Ms. Wright. Have a great day.
You too.
Thank you, Your Honor.
Thank you,
Attorney
Mr.
Horka.
Mr. Horka.
Yes, Your Honor.
I'll call a few names. In the meantime. You're off. Unique Owensby. Unique Owensby. No. Is Mario Brown here? Good morning, Attorney Lockhart.
You're muted, Steve.
Mr. Lockhart, what case are you on this morning?
Judge, I'm a half hour early for file ending 113 at 10 o'clock. I thought I'd see if by chance LeMay Evans or any occupants on Lappin were available.
Okay. Is LeMay Evans here?
I am not seeing it on your Zoom, Judge.
All right, well, sit tight and we'll get this called at some point. So I'll call it again. Are you Miss Lene Evans with Zoom user? No? All right, I think we can just unmute and then figure out what you're saying.
I was on there with the lawyer. I'm on my daughter's phone. I don't know how to use no iPhone. And we got disconnected and I was telling him what was going on.
Your Honor, she was in with
Is this Miss Madison?
Okay, thank you.
You're Miss Madison, right?
I found it.
Yeah, sorry, I didn't mean to mute you.
Yes, Ryan, ma'am.
Sit tight, attorney.
I had to push cellular Wi-Fi.
Your Honor, I put her back in breakout room 9 with Attorney Santiago.
Okay. All right. Let's call. Is Andiana Green here? Andiana Green. Let's see if she's on the Galaxy S9 Plus. Let's see. Samsung S9 Plus. What's your name? Sir, what's your name? And you gotta put a shirt on, sir.
Oh, me? Oh, I'm sorry. Man, he on here. I think you was on the wrong thing.
It's all right.
I'm sorry.
What's your name, sir?
Transasha Washington.
Okay, and what time are you scheduled? I see you.
I think
8:30.
Yeah, we've been on here waiting. I think we was on the wrong thing. Are we late?
No, you're all right. I mean, it's 8:30. You were scheduled for 8:30, but you're okay. You're here. You're here now. So we'll get it done.
Do you see me?
Attorney Horka is the attorney on the other side. Do you have an attorney?
No.
And do you want an attorney?
Yes.
All right. Your voice has distinctly changed, Mr. Washington.
No. Tell him.
We had put in two of them, so because I've been on this one since 9/8/26, and I haven't had anything.
Okay, I'm gonna invite you into a breakout room where legal aid, where you can speak to legal aid. It's gonna be breakout room. And Ayla Smith.
Can you press it again? I unjoined it. I'm sorry.
See, I have to find you.
It say waiting on the host to start this meeting. Okay, join.
Okay, so they're in room 12. Well, you all probably invited them to room 12. And Ayla Smith, see, you're trying to get the court's attention.
Oh, hello. I wasn't able to change the name on the screen. This is Miss Gwendolyn Trimble. She has court today. I'm her case manager.
Okay, thank you for letting us know.
Mm-hmm.
Ms. Trimble?
Yes, Your Honor.
Good morning.
Good morning, Your Honor.
Good morning. Good
Good
morning.
morning, good morning, good morning, everyone in the city of Detroit.
All right, Ms. Gwendolyn Trimble, I have you checked in. Do you have an attorney?
At her last court date, they did give her Miss Germain for legal assistance.
Well, when I got the papers from 36th District Court, it said Aaron Cox.
Yeah, so Aaron Cox is that's the landlord's attorney, and
but I've never spoke with him or anything. I just got the 36th District court date today, and that's it.
okay. Now, is Ms. Germain, have you talked to Ms. Germain?
No, we have not. Not since the previous court date.
Okay. And, all right, let's see. Do you have her contact information?
I do have her cell phone number, yes.
Try to give her a call and see if she's actually representing or if she's advice only. And if she's advice, we'll move forward. If she's representing her, we'll wait until she logs in.
Okay, let me go give her a call right now.
Okay, thank you. I'm going to place your device on mute, Ms. Trump. Calling case number 2334-670, Dunmar LLC versus Andiana Green.
Good morning, Your Honor. Marlene, plaintiff, standing in for attorney of record Elaine Marty-Rosian, P69505.
Thank you. And it's Andiana Green here. Andiana Green. Does anyone live at 14926 Tireman? Looking at the screen. I don't see anyone responding. Motorola 5G with the Kofi arm. I don't know. That doesn't look like Andiana Green. If your name is Andiana Green, okay, and that's Rosalind Harris Gates. Okay, great. That's what I wanted to make sure it wasn't Ms. Green. All right, Ms. Green doesn't appear to be present, counsel. What would you like for the court to do?
Your Honor, requesting a judgment. The total amount is 4617, and that includes 4382 in rent and 35 in costs. So requesting a default judgment along with a money judgment. And request, I'm not sure how much to give, Your Honor. We would request 10 days.
All right, was personal service executed in this matter?
Your Honor, I'm just covering from a lane for a lane at the last moment. I'm not aware of what kind of service was obtained.
Okay. I'm gonna check the ROA and see if we make sure we have service. 670. All right, and you cut out when you were mentioning the court costs. I heard the 35, but I didn't hear the first digit. Is it 135?
It's 235, Your Honor.
That's right, money judgment. All right, and that total is 4617?
Yes, Your Honor.
Okay. Okay, and it does show in the register of actions that the summons and complaint was heard by Bailiff Mason. Okay, so defendant has failed to appear. However, they can redeem this amount. The amount to redeem is $4,617. They can redeem their property for $4,617, but that amount must be paid by June 5th, 2023, or a writ of eviction can issue after that date. This is a money judgment. Personal service was perfected on was this May 16th, 2023. Defendant failed to appear. Counsel, please submit a default judgment to the court and we will sign it.
I will do that. Thank you.
You're welcome.
Your Honor. Sorry, that was Attorney Braley. The person on the Motorola Moto G is connected to audio now.
Yes,
Okay.
What's your name?
Curtis Samuels.
Is it ready, Pop?
Is Gail Madison still in the breakout room? Let's see.
Judge,
Gail.
I am talking with Miss Madison, and I came out here to see if I could talk to the plaintiff. Has Callie Logan checked in, or is there an attorney for Miss Logan?
Yeah, she's here. I'll invite you all. I'm going to invite her to room 17.
Thank you.
Cool.
Okay. Mr. Samuels, I'm gonna mute you for now. Okay, there's a microphone button when you need to unmute, hit that, but your case isn't up until 10.
Yes, ma'am.
And is he represented by counsel, Ms. Bradley? Mr. Samuels? Do you have an attorney?
I don't think so.
In our emails.
The training for what?
Mr. Samuels, do you have an attorney? Do you want to talk to one? Okay.
I have 776, 777, 778, and 779, all with the same plaintiff and defendant, by the way.
I see that, Your Honor.
So let's look at these files.
And Your Honor, I don't know if it would be possible to have those scanned over so we could take a look at them, since it's a health hazard and we'd really like to make sure that it was filed properly.
Right.
And also see what the reason for the health hazard is.
Mr. Samuels.
He needs to click the microphone button to unmute. He's unmuted.
Mr. Samuels, I see you're on 4 cases.
4 cases?
Yeah. Are you occupying multiple units?
Yeah.
Okay. I just wanted to check. I'll call your case. Your case is scheduled for 10. I just wanted to ask you that.
Yes, sir.
Okay. Is Christopher Donahue here? Christopher Donahue. One 178. Where's 178? Does anyone reside at 3063 Parker Street? 3063 Parker. All right, and Attorney Lamont.
Yes, Your Honor, I have a resolution with Attorney Simon, but I think oh, there he is. Mr. Simon,
Ready.
are you ready? Okay, it is case number 6727.
Calling case number 23346727, Belmont Properties versus Alex Hill.
Yes, good morning, Your Honor. William Simon on behalf of the plaintiff, 80352.
Suzanne Steppens-Lawand, P48702, Michigan Legal Services, on behalf of the defendant, Alex Hill, who is with us in the courtroom. Ms. Hill, will you unmute your device and state your name for the record, please?
Alex P. Hill.
Thank you.
All right, the party's able to work out some type of resolution.
Correct, Your Honor. I had a chance to speak with Ms. Lawand, and we decided, or we'd like to ask the court to enter into a judgment by hearing against all occupants. The total amount owed is $1,875. That's including $160 in court costs, and that would be due on or before June 24th, 2023.
That's correct.
All right, the court will enter a judgment by hearing where all occupants The named party is removed, who is Alex Hill. Alex Hill's name is removed. This judgment will be entered as an all occupants judgment, where $1,875 must be paid by June 24th, 2023, or a writ of eviction can issue. So this $1,875 or vacate by June 24th, 2023. Ms. Hill, do you have any questions?
No, sir.
All right, counselors, did I miss anything?
I don't
No,
believe
that's
so,
it,
Your
Judge.
Honor.
All right, court to enter this judgment, and we'll sign the judgment once it's forwarded over.
Thank you, Your Honor.
Thank you, Your Honor. And Ms. Hill, you're free to go. I'll be in touch with you later.
Okay, have a wonderful day, you all.
You too. Thank you. Right, that was Alex Hill, Ms. Trimble, and then Mr. Dad. Ms. Trimble.
Hi, so I was able to get in contact with Mr. May. She was, she's not the attorney.
Okay. All right, let's see if we can get you in a breakout room with Mr. Horka.
Okay.
I'll invite you all both to a breakout room, and if you all can work something out. Now, you can now hear the case. So let's see. Gwendolyn, where are you?
8:30, last 3:27.
I invite you to room 15.
It says he's Lusher.
Yep, so you've been invited into a room. Click that join button. All right, Mr. Dad.
Yes, Judge, I have two cases from 8:30. I believe we're ready for defaults. I don't see the tenants.
Is Deja McClure here? Deja McClure. Calling case number 2334-7271. This is Sweet Properties versus Deja McClure.
Good morning, Your Honor. For the record, Rania Haddad, P84927 on behalf of the plaintiff.
Thank you. Good morning. Is Ms. McClure here? She doesn't appear to be present today. Counsel, what is your request?
Your Honor, we move for a default judgment for knowing is $2,032.55. That is inclusive of $160 of attorney fees and costs.
All right, default judgment is granted. Defendant failed to appear. Defendant must pay $2,032. That's 2032.555. What was you requesting a 10-day statutory period, counsel?
Yes, Judge.
All right, by June 5th, 2023, or a writ of eviction may issue. Pay, must pay or vacate by June 5th, $2,032.55, 7271. Calling case number 2334-7272. This is Sweet Property Management versus Antoine Jefferson.
Good morning, Your Honor. For the record, Rania Haddad, P 84927 on behalf of the plaintiff.
All right, good morning. Does anyone live on Sorrento? 18961 Sorrento. Doesn't appear that Mr. Jefferson is present. Counsel.
Your Honor, we move for a default judgment for possession. The balance due and owing is $14,160. That is inclusive of attorney fees and costs. And we are requesting a pay or vacate date of June 5th.
All right, defendant failed to appear. Default judgment was requested. Default judgment was granted. This is a non-payment of rent case where $14,160 is the amount to retain the property. In the event that amount is paid, no eviction will be filed. In the event the tenant moves by June 5th, no eviction will be filed. However, if defendant fails to do either or, a writ of eviction could issue by June 5th. So parties must pay $14,160 or vacate by June 5th, 2023, or a writ.
Thank you, Judge.
You're welcome. Mr. Santiago.
Good morning, Judge.
Good morning. Do you have a matter ready?
Yes, well, not necessarily ready, but we were not able to reach a resolution.
All right. Keep your hand up, Mr. Santiago.
Certainly. Thanks, Judge.
Okay. I'll recall your case. Mr. Saman.
Yes, Judge, we're ready on case ending in 729 with Mr. Yancey.
On case number 23346729. This is Angel Group LLC versus Alan Yancey. May I have appearance?
Yes, good morning, Your Honor. William Saman on behalf of the plaintiff 80352.
All right, and Mr. Yancey, can you state your name for the record? It's star 6.
Hello, can you hear me now?
Yes, sir. Can
Yep.
you state your name?
I'm sorry. It's Alan Campbell Yancey Jr.
All right, thank you, Mr. Yancey.
Yes, sir.
Jr. All right, Mr. Saman, were you able to come to some type of agreement with Mr. Yancey?
Yes, Judge. I had a chance to speak with Mr. Yancey in a breakout room, and we'd like to ask the court to adjourn this matter for 30 days to allow Mr. Yancey to get caught up before any judgment enters. He indicated that he could make the payment before then.
Okay, so let's just do. June 20th. Is that enough time, Mr. Yancey?
Yes, sir. It should be enough time for us to do what we need to do.
All right, the court finds good cause to adjourn this matter to June 20th, 2023 at 9 a.m. We'll be in person that day.
All right, thank you, Your Honor.
If you get it resolved before then, make sure you notify the court so you can save a trip.
Yeah, will do, Judge.
Okay.
Yep. Blessing on you, Your Honor. Thank you.
Thank you.
All right. Take care. And is Donna Higgs here? Donna Higgs. Donna Higgs, are you here? All right. Mr. Mazi, and then Attorney Cohen.
Yes, Your Honor, I didn't know if Attorney Saman was ready for our case ending in 726.
Yep, I'm ready.
Calling case number 2334-6726. This is American Tax Refund LLC versus Dave Smith and all occupants.
Yes, good morning, Your Honor. William Saman on behalf of the plaintiff 80352.
Good morning, Your Honor. Lauren Namazi, P85424, Michigan Legal Services, on behalf of the defendant Dave Smith, who's present in the Zoom gallery.
All right, Dave Smith, can you state your name for the record?
Dave Smith.
Thank you. All right, counsel, would you all like to put the terms on?
Yes, sure, Your Honor. Yes, me and Ms. Namazi were able to work out a judgment where the total amount due and owing as of today, Judge, is $9,410. That includes $160 in court costs. Parties have agreed that the defendant will pay that by June 26, pay or move by June 26, 2023. And this judgment will be against all occupants only.
All right, Mr. Smith.
Yeah.
Your name is being removed as a named party in this judgment, and the judgment will be entered into all occupants. But all occupants must pay a total of $9,410 by June 26th or vacate. Do you understand that?
Yeah.
Okay. This will be a judgment, a hearing by judgment. Judgment hearing. All occupants must pay or move by June 26th, and the amount is $9,410. Good luck, Mr. Smith, and you have a great day.
Thank you, Judge.
Thank you, Your Honor.
Thank you, counselors. Attorney Cohen, and then Attorney Devlin, and then Ms. Fisher. Is Anthony Wright here? Anthony and Joseph Wright?
Yes.
All right. Have you talked, do you have an attorney? Have you talked to Attorney Cohen?
No.
Okay. And Patricia Parks?
Yes.
You're on the docket today as Anthony Wright?
Yes.
Okay, I'm just making sure. Do you reside on Lafayette?
Yes.
Okay. Change your name. Is your name Patricia Parks?
Yes.
Okay. 201. Do you want an attorney, or do you want to speak to the landlord's attorney?
I really don't need an attorney because we're moved.
Attorney Cohen, is 201 a dismissal? And good morning, by the way.
Oh, good morning, Judge. I'm sorry.
Good morning.
Good morning.
I'll call it. Calling case number 2334-7201. This is Cityside Owner LLC versus Anthony and Joseph Wright.
Carolyn Cohen, P493. Carolyn Cohen, P49391, appearing on behalf of the plaintiff. I don't believe these defendants have appeared.
Ms. Parks,
Joseph.
Here.
Oh, they're here. I'm sorry. Are they here?
No, their mother is here. I'm their guardian.
Are you a leaseholder?
No, I'm not. I'm on their guardian. I'm the guardian on their lease.
Well, I see a lease between Anthony and Joseph Wright.
Yes, and I have guardianship papers over both.
They have not called you.
And do you reside on East Lafayette Street?
And being reconnected.
Anthony and Joseph resides on East Lafayette Street.
Okay, and are parties still on East Lafayette Street?
No, sir. We moved. The doctor submitted a letter to Cityside stating that Joseph and Anthony, due to their conditions, need to be moved, placed in a better placement because both of them requires total care. I submitted that letter to the lease office. They told me that I had until the 31st of May to remove them. And I started removing them as of yesterday.
So you still have, we don't have possession of the apartment, do we? You haven't turned in the keys?
No, I was gonna turn them in tomorrow due to the fact I just wanted to sweep it out and clean it up a little bit more.
All right, well, then maybe we could just do a judgment after a hearing that either 1,168 needs to be paid or they vacate.
They have vacated.
Okay, is there any objection to no occupant's judgment?
No, no objections.
All right, so this is what Ms. Sparks.
Yes, I'm listening.
So this is what we're gonna do in lieu of coming back to court for maybe the same result. There's an amount due. Ms. Cohen, Attorney Cohen, does not object. She's removing the named parties of the defendant. So this judgment will go in all occupants will have 10 days to vacate or to pay the $1,068. So you can either pay or vacate, but the judgment won't affect your kids, children, or your who you're taking care of.
Okay, they'll have their keys Friday because I didn't vacated them. I just gotta clean the apartment. I didn't want to leave it dirty.
Okay, I'm sure they appreciate that. So
yes,
it'll be a judgment, and the judgment will be for all occupants to vacate by June 5th, 2023. That keeps us from having to come back to court in the event something happens. Attorney Cohen accomplished her goal, and their names are removed from the judgment. So sort of a win-win in my opinion, but.
Okay. All right, thank you.
Welcome, good luck.
Okay, thank you.
It's Theodore Dobbins Jr. here. Theodore Dobbins Jr.
Yes.
All right, Theodore Dobbins Jr., good morning.
Morning.
Attorney is here. Now, have you spoke to an attorney, Mr. Dobbins?
Yes, he has, Your Honor. I'm representing him. This is Attorney Fisher.
Okay, Attorney, have you had an opportunity to speak to Attorney Cohen?
Yes, we ready.
Okay, well, I'm ready if you're ready, so let's call it. Case number 2334-7202, Cityside Owner LLC versus Theodore Dobbins.
Carolyn Cohen, P49391, appearing on behalf of the plaintiff. This is a subsequent hearing on a non-payment of rent case for the property located at 2671 East Lafayette Street, number 1 in the city of Detroit.
All right, thank you.
Jonetta Fisher with Michigan Legal Services, 72872, representing Theodore Dobbins Jr. Mr. Dobbins, please state your name for the record.
Theodore Dobbins Jr.
Thank you, Mr. Dobbins. All right, will parties like to put the terms on record?
You want to go ahead, Ms. Fisher?
Yes, Your Honor. This is going to be a CD consent conditional dismissal 4B. The balance owed as through May is $2,328. He will pay, the tenant will pay $1,000 by tomorrow, 5/26/2023. And then by June the 23rd, 2023, he will pay $2,363.
And those amounts are through June 30th.
Okay, and that amount, so that amount totals $3,363?
Yes.
Correct.
Okay. Okay, I see what you're doing. You added the rent to the June amount?
Correct.
Okay, all right, the court's satisfied. If you all are satisfied. Did you explain what 4B was, counsel?
Oh, I did not, Your Honor. I'm sorry.
No worries. 4B means it's a box. It's 4A or 4B. 4B is checked on as conditional dismissal. So it means that a judgment and a writ of eviction can be filed at the same time without coming back to court. But if $1,000 is paid by the 26th and 2363 is paid by the 23rd of June, this matter is dismissed. So as they stated, June 30th will be the deadline to fill the entire balance, but this matter will be dismissed if you fulfill those conditions. Any questions, Mr. Dobbins?
No, no.
All right, does your attorney have permission to sign your name on the document?
Yes.
All right, okay. Well, I'm satisfied. Did I miss anything, Counselor?
No, Your Honor.
All right, well, thank you, Attorney Fisher, Attorney Coleman.
Thank you so much. Have a great day.
Excuse me, Your
All
Honor,
right.
there's a lot of noise in the background. It's hard for me to hear. I don't know where it's coming from, but I can't hear it.
Okay. Let's see if we can fix that. All right, Mr. Dobbins, you have a great day.
Thank you.
Okay, what are you calling for? What are you trying?
Is it better?
Yes, right now, I don't hear anything. Yeah.
Okay. A lot of people checking in late today. Well, it might be 10 o'clock, but. All right, is Lene Evans here? Lene Evans?
I'm gonna transfer you to facility.
All right.
Hello.
Hello, are you Lene Evans?
No, Latanya folks.
Tanya, can you give me that last name again?
Folks, F is in Frank, OWLKES. I was in a breakout room, but they didn't come back.
Actually, Judge, I was with Miss Folks, and I was waiting for Mr. Horker. I'm going to pull her in the breakout room and relabel her.
Okay, thanks. All right, sit tight, Ms. Folks. You have an attorney.
All right, thank you.
You're welcome. Attorney Lockhart, I know you're early. I called defaults an hour after. Still don't see Lene Evans here.
You wish me to come back at 11, Your Honor?
It's up to you. It's whatever you wish to do, Mr. Lockhart. Just come back at 10, pop in at 10:45, see if she's here. And I'll call your default at 11 if she's not.
Thank you very much, Your Honor.
Listen, if she's here. No problem.
Hey, Keela, what's the guy name who you go to court with? What's the guy name who in your house? Oh.
This is Attorney Adam Devlin. I have two 830 defaults.
Okay, I'm gonna call your case. You're next, counsel.
Thank you, Your Honor.
You have two. I see one on here.
I've got two notices.
And 178. What's your other case?
176.
It's the what?
That's you.
Oh,
What?
I get the where was I from, huh?
All right. Hold on 1 second.
They're not picking up.
Calling case number 2334-7178, north of Kirchhoff versus all occupants.
Your Honor, Adam Devlin, P72877 for the plaintiff.
All right, thank you, counsel. Does anyone reside at 3063 Parker Street?
What address do you have? What is your address on here?
3063 Parker. Let's see, it's iPhone. Lives on Parker. If you live at 3063 Parker, please unmute.
Hey, hello.
Hello.
Good morning.
Good morning. Do you reside at 3063 Parker?
No, I'm sorry.
Okay, hold on 1 second. We'll check you in shortly. Ms. Trumbull, I know you don't reside at on Parker Street. All right, counsel. What is your request?
We asked for a default judgment to enter writ date at the 5th of June. Possession only. This is termination.
Okay, let's see. I have proof of service, counsel. Thank you for including the deed. All right. Default judgment is granted. Defendant failed to appear. This case was scheduled at 8:30. It is now 10:14. And it's failed to appear. This is a termination of tenancy case, no amount to redeem. The parties must vacate. All occupants must vacate by June 5th, 2023, or a writ of eviction may issue. And that concludes this matter, 7178. We will, let's see. Yeah, 7176, counsel.
Yes, Your Honor, set for the same time.
Check it.
That was my lawyer. I didn't know how to talk to her.
I'm checking out the ROA right now, counsel. Let's see what's going on. I get all second hearings, so I hope it's that.
I'm here.
That was 3-0.
I'm sorry, did you call Kyra Morgan?
No, Miss Morgan, I didn't call. Didn't call you yet. 307. 7176 is 3065 Parker.
Yes, Your Honor.
All right, calling case number 2334-7176, north of Kirchhoff LLC versus all occupants at 3065 Parker Street.
Your Honor, Adam Devlin, P72877 for the plaintiff.
All All right, does anyone at 3065 Parker Street? Doesn't appear that anyone is present, council. Are you
We'd
requesting?
ask for default, we'd ask for default judgment to enter possession only, writ dated the 5th of June. Or this is a termination.
This is a termination case. No rent to redeem. Defendants, all occupants in this matter must vacate by June 5th or a writ may issue.
Thank you, Your Honor. I'll submit both by fax today.
All right, you have a great day. Take care. Mr. Kemp, good morning.
Good morning, Your Honor.
So you had your hand up. How can we help?
I'm wondering if she responded with a default. And I also had another question. I was before you last month on the 21st, and you entered a default judgment. I've been down to the court several times, and they keep saying that the judge hasn't signed the order. So it's been a whole other month. Wow. Yes, sir. Yes, Your Honor.
I got another stat. So today I'll be signing a lot of orders. They pile up by the day. So today I only have an afternoon docket. Hopefully yours is in here and we'll get it back to you. Or it may be signed and then processed. But all this will come to an end too. So keep an eye out for it, but it's a little backlog.
Okay.
So,
okay, Your Honor, I understand.
So yeah, that's, it's got to get inputted too. So we'll get it back to you.
Okay. Okay.
Yes, are you this morning?
Excuse me, I didn't catch that.
And what matter are you on this morning, Mr. Kemp?
Ms. Fisher.
What's the case number?
1869 Bassett. I don't have the case number with me right now.
Is it in your name?
Yes. It's on the docket for 8:30. This is the second hearing.
Okay. See if you can track the case number because where'd it come from? What court were you in last?
I think it was Miss Kenny.
Oh, okay. Ms. Kennedy. We're gonna see if you can track me down.
Okay.
Keep your hand up and I'll get back to you. The clerk is gonna try to check to see if your case is, we'll find out what's going on. He doesn't have a case number.
Okay, thank you, Your Honor.
You're welcome. You're welcome. If you come with the case number, just pop it in the chat. Mr. Santiago.
Yes, Judge. I believe I have one case ready with Mr. Horka. I believe he's in a breakout room with some of my colleagues. And then there was the other case where we were not able to resolve it. It was as pro per landlord.
Okay, and which case was that?
That one was case ending in 6752. It's Miss Logan is the landlord and Miss Madison is the tenant.
Okay. 6752. Okay, Gail Madison and Kylie Logan. Let's call it. Calling case number 2334-6752. This is Kylie Logan versus Gail Madison.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157. On behalf of the tenant, Ms. Gail Madison, who is present in the courtroom. Ms. Madison, if you could unmute and state your name for the record.
Madison. Madison calling in through the phone. Let's see.
I'm not sure if she may have been disconnected, Judge.
I'm here.
Oh, there she is.
Good morning.
Could you state your name for the record, Ms. Madison?
No, Madison.
And Miss Logan, Kylie Logan, can you state your name? Kylie Logan?
She's on the call-in phone. She needs to unmute.
Can you hit *6 on your device, Miss Logan? Miss Logan, looks like you're unmuted. Can you state your name for the record?
Yes, Callie Logan.
All right. Thank you, Miss Logan. All right.
You're welcome.
You're welcome. Did you have an opportunity to speak to Mr. Santiago?
Yes, I did, sir.
Okay. I understand you all weren't able to come up with an agreement, so I'll try my best to move this along. Okay, there is proof of service, there's a summons and a complaint for recover possession of the property. Now, Ms. Logan, you own the property. You own the property at 10598 Marr.
Yes.
All right, Ms. Madison, are you still in the property 10598 Marr?
Yes, I am. I had found a place, but they scammed me, so I start all over again. And I'm disabled and I got my grandchildren here with me. And I've been trying to find a place, but it's been hard. So I did talk to the housing authority and they trying to help me right now.
Okay. So how much?
Judge?
Go ahead.
At this point, we are asking if the court would give Ms. Madison 30 days to vacate. As she indicated, she is disabled. She is caring for her 2 grandchildren. She is being assisted by United Community Housing Coalition, but it's been difficult. She thought she found a place and it ended up that someone had scammed her. So she lost a significant amount of money for her situation.
Okay. Ms. Logan, how much time are you willing to give Ms. Madison?
7 days.
All right. Well, the law gives you 10 automatically. Ms. Madison.
Okay,
So,
well, 10 days, sir.
okay, the court's gonna take in consideration what was presented by both sides. I'm gonna extend your 10 days and meet you all somewhere in the middle. What, today's the 25th. 10 will put you at June 5th.
Okay.
17 will put you at June 12th. So I'll do June 13th. And a writ wouldn't be able to be filed by June 15th.
Okay.
Actually, scratch that. We'll go June 16th move out day. So that's
okay.
We'll do a
Judge,
June.
would the court consider this as a judgment by hearing against all occupants to further assist Ms. Madison?
Now that's totally up. That's totally up to Ms. Logan. Ms. Logan.
Yes.
Are you willing to enter this judgment as an all occupants judgment? It may assist Ms. Madison in finding housing after this case is over. It's totally up to you. Your decision.
I done gave her almost 3 years. She haven't paid rent in 3 years.
Use a lot.
It's a yes or no, Ms. Madison. I mean, it's a yes or no, Ms. Logan.
No.
All right. Well, judgment by hearing where Ms. Logan, Ms. Madison, you must vacate by June 16th or a writ of eviction may issue. Right, that concludes this matter. Good luck, Ms. Madison. Good luck, Ms. Logan. You all have a great day.
Thank you. You do the same.
Thanks, Judge.
You're welcome.
And did you want to call the one with Mr. Horka or not? We did come to an agreement on that matter.
Okay, which one? Which
It is 7242 Garden View Estates versus Latanya folks.
Yeah, I just want to know what's the specific.
7242?
Correct.
Second.
And Your Honor, when you said it's paid for vacate.
Hold on 1 second, Mr. Santiago.
Hey, Pop. Come here.
Got 47 people.
All right, and then we'll go, Mr. Gross or Gross? How do I pronounce your last name?
Gross, Your Honor.
Gross, okay. Mr. Gross, you are going to, you're on deck. I'll do Mr. Santiago, and then I think you have one with Mr. Santiago, correct?
It's actually kind of a housekeeping matter, but we can address that.
No problem. All right, can you give me that case number one more time, Mr. Santiago?
Sure, it is 7242 are the last four.
Calling case number 2334-7242. This is Garden View Estates 5 versus Latanya Folks.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157. On behalf of the tenant, Ms. Latanya Folks, who is present. Ms. Folks, could you please state your name for the record?
Latanya Folks.
All right, thank you, Ms. Is Mr.
I
Horka
am not
present?
sure if Mr. Horka has left the breakout room yet. He is being held hostage by Ms. Lawand and Ms. Fisher at the moment. If the court would like, I can place the terms on the record of what we agreed to.
Sure, I don't think Mr. Horka would object to that. And parties have already come to the agreement?
Yes, Judge.
All right, please place the terms on the record.
It would be a conditional dismissal under 4B with a pay or vacate date of June 30th, 2023. The amount owing, according to Mr. Horka, was $3,079.
All right, so $3,079 must be paid by
June
And
30th.
that does occur. Ms. Folks, your case will be dismissed. If that doesn't occur, if parties don't vacate or pay $3,079 by June 30th, then a judgment and a writ of eviction can issue at the same time.
Okay.
Without having to come back to court. So I just wanted to let you
And Judge, just as a caveat, I believe that was included the court costs, but if they don't, we will adjust the CD accordingly.
Okay, and it shouldn't exceed more than, this is not a money judgment, so the court cost wouldn't exceed $200. Just that's
correct, Judge.
So,
thank you.
You are welcome. Ms. Folks, do you have any questions?
No, I don't.
Okay, all right, good luck. Have a great day.
Thank you, you too.
Thank you.
All right, do you want me to stick around and deal with the case? Mr. Gross is substituting in on a case.
Sure. And then Ms. Trumbull, I see you're waving your hand. I'll get to you.
No disrespect, Your Honor.
No, it's no problem. All right, where is this? Calling case number 2-3-4-5-3-2-9. This is Keela Nealis versus all occupants.
Mr. Flesland is here for Mr. Sagatti.
Okay, and these are all occupants. All occupants at 6321 University Place. May I have appearances, please?
Yes, sir.
You muted yourself, Dennis.
I know, I muted them by accident. Sorry about that. Go ahead.
Dennis Flesland, P30289 for the plaintiff.
Good morning, Your Honor. Robert Santiago, Michigan Legal Services, P57157. I did represent the occupant, Mr. Deontay Manier. I have since been in communication with Mr. Manier, and he indicated that he hired his own attorney, and I believe that is Mr. Gross. And both Mr. Gross and Mr. Manier are present.
Good morning, Your Honor. Good morning to your staff, Robert Gross, P82012. That is an accurate status of this matter. I would just note that the register of actions, because I did get assigned substitution of counsel, it indicates that Mr. Santiago is still on the case and that I'm now representing the plaintiff in this matter. So that's just a clerical error. I'm substituting on behalf of
So
counsel.
Mr. Flesland is out of the formula then? We can dispose of him? I'm kidding. Sorry.
Don't do that. I mean, first the judge mutes me and then you want to dispose of me? I don't know.
So at this point, Judge, am I excused? Will the court grant the substitution?
Absolutely.
Thank you.
Granted substitution, you are excused, Mr. Santiago, and we can proceed today. Parties are ready, so maybe I'll give you all both breakout privileges, and if you all want to talk in the breakout room, feel free, and when you come up with a resolution.
Okay, that's fine, Judge.
All right. Okay. All right, well, welcome on to the case. Welcome, Mr. Gross.
Thank you.
I see the landlord for University Place is there. I'll have you put your name on the record when I recall the case, ma'am. All right, thank you. Okay, and Ms. Trumbull. Ms. Carigian, do you have something?
Yes, Your Honor. I'm just here for a 10 a.m. case, and I do see that the plaintiff is here, and I think that my client may be an unidentified device in the gallery.
Okay, well, what case? And
It is case ending in 754.
okay, Bruce Dinkins. Bruce Dinkins. Bruce Dinkins.
Yeah. Yes.
All right. Your attorney is here. I'm going to invite you to a breakout room with her, okay?
Okay.
All right. You can traverse through the, yeah, you'll be able to get out of the breakout room, which is important. So, 8, you'll be invited to room 8, Mr. Dinkins.
Okay, room.
See something on?
Yes, I see it.
Okay, all right. And Ms. Trump, hold on one second, Ms. Trump. Attorney Phillips.
Your Honor, I have a 10 o'clock that is not settled, but the parties are ready to present.
One to 10 o'clock.
5626 with Mr. Bajani.
Is this Mr. Bajani's only matter?
Yes.
All right, get him out of here. Calling case number 23345626, Luke's Property Management versus all occupants.
Good morning, Judge. Eli Bajani, P 74626 on behalf of the plaintiff, and I do have the property owner in here as well.
Okay.
Morning.
Go ahead.
Ted Phillips, P 35900, and the occupant, Kenneth Lewis, is also present.
All right, Mr. Lewis, can you state your name?
Kenneth Lewis.
Thank you. All right, parties weren't able to work out a resolution. Is that
Your Honor,
what's going on?
I did file a answer affirmative defenses counterclaims demand for reply request for discovery and removal this morning. I'm sorry, it was this morning. And if Mr. Bajani needs time to respond to that, I am perfectly open to that. We would think, though, for moving things along, it might be beneficial to either set a trial date or hear the removal issue and remove it to circuit court. The claim here by Mr. Lewis is that essentially he had a land contract with the plaintiff. There was an agreement in 2019 that the property would be purchased, that he's occupying. The property was vacant, doors open, no windows, etc. The property would be purchased for $1,000 plus some work to be done on the plaintiff's personal residence. And the defendant was taking the property subject to rehabbing it and paying taxes on it. He has rehabbed it. He has paid taxes on it all of this time. He has done substantial work on the plaintiff's home. My client got injured, was not able to finish all of the work timely, but there was still that agreement. There are text messages back and forth which confirm some of this. And the last agreement was that if $1,250 was paid from Mr. Lewis to the plaintiff, that the deed would transfer. The $1,250 was offered, but not accepted by plaintiff. So I would argue that this is basically has all the elements of a land contract. There's been an agreement, there's been performance, there's been payment, and that there should be an enforcement of that. I think that would have to be in circuit court, or there should be a quiet title, and the title should be granted to my client. But in either case, I recognize I filed a lengthy response. I did not intended to be so late. I apologize, but I did file it with the court, and it was emailed to your clerk this morning, Your Honor.
Okay. Mr.
Judge.
Johnny?
Yes, Judge, thank you. This is our third hearing. This is for a termination of tenancy, and we don't wish to belabor this case any further, so we're hoping to resolve it today. The main issue here is that nothing was in writing between the parties as required under the statute of frauds. More specifically, it's Michigan MCL 566-106, which states that any conveyance of property has to be in writing, and it must state the names of the parties, signatures of the parties, and a description of the property. None of that was done here. The defendant has lived in the property for 4 years for free. Maybe he did make some repairs, but my client is claiming that he started some repairs and never finished anything and just kept making excuses as to why he couldn't finish. My client is here to testify on his own behalf. So there's no deed, there's no lease, there's no land contract, nothing is in writing between the parties. And texts and emails, they don't satisfy that writing requirement.
An email could.
Well, it doesn't satisfy the requirement to convey property. It would have to be signed by both parties.
Any parties can sign an email. And we're sending digital signatures all day for the last 2 years.
I use digital signatures, Judge, but I'm saying if the defendant is trying to produce text messages between the parties, that doesn't satisfy the writing requirement. And e-signatures are, yeah, of course, I e-sign all my documents, but it wasn't e-signed. And you have to describe the property, and it doesn't have to be recorded, but it should be recorded as evidence with the Wayne County Register of Deeds. None of that was done, Judge.
Brief response, Your Honor.
Sure.
Your Honor, there are text messages. My client has asserted that, but for finishing the bathroom at the plaintiff's residence, the deed should have passed. There is a text message, no problem, from plaintiff. No problem, though. As soon as I get the bathroom done, I'll let you know what you owe me for the deed. I mean, there clearly is some evidence here. It is very convenient, of course, for plaintiff to have an abandoned house that cost $2,199 in 2017 that was purchased from the Wayne County Treasurer, to dump that on the defendant, have the defendant put in a furnace, hot water heater, basically rehab the place, and now want to stand back and say, well, there never was any deal, when there clearly is evidence in the form of text messages. I would ask that there at least is a triable issue here, and that this matter should be set for trial with some discovery granted so we can dig deeper. We do know that there was at least $2,400 paid in taxes. The taxes are not very high on this property. Going back to 2019, the taxes wouldn't have been much more than that. I've attached a document to my pleadings which verify that. So I would ask that minimally the court set the matter for trial, and grant discovery, and or allow the case to be removed to circuit court.
Judge, my client he wishes to address the court directly.
Yeah, I had to leave that courtroom because I had to. Yeah.
I'm not you, Fussland. Lucas, do you have something to add to that?
Yes, I do. May I speak?
Sure. Do you swear to tell the truth, nothing but the truth?
I do.
All right. Can you state your name?
Lucas Johnson.
Lucas Johnson, how are you related to the property at 7611 Weatherby?
The owner.
Okay. And is there someone currently occupying the property on Weatherby?
Yes, Ken Lewis has been there for years now without paying any rent or without basically squatting in the property. I never tried to take possession of the property because we have been busy for the last year or two with other things. We had a verbal agreement that he was supposed to do some work for me. And it was finish my primary bathroom and come with a certain amount of money. And we were going to do a deal on the house, but he never finished his work. I mean, he took probably like months, kept blowing me off. I have texts too of every date and everything, all his excuses of why. Now this job may have taken about a month to do, but he blew me off and he never did the work. My main bathroom in my property was out of order for this long. I mean, the only bathroom pretty much that had a tub and a shower in it. So I think he has, I don't know, his personal life, but it's so many excuses that he gave me. And I have all this on text messages. We never put anything on paper. We never had any type of emails, but he pretty much screwed me over on the deal. And then when he figured out that he screwed up on the deal, he tried to offer me a certain amount of money for the property. Plus, it was years later, and the property had went up in value. Plus, the property is still dilapidated. We can go by today and take pictures of the properties. No windows in the house. It doesn't even look habitable, actually. But I'm not willing to do anything further with him. And I stated this before. He had certain side jobs that he used to do for me. I got text messages on all these side jobs. One time he did a job, we paid him full price. He didn't finish the work. I got plenty of text messages with everything that's going on. So whatever they want to do, take the case to another level. I mean, it's fine with me. I got as much proof as he has. And like I said, this was all verbal. It was never anything put on paper. And I've been looking out for this guy. You can look at all my text messages. I've been Mr. Nice Guy for months and months and months and months. And all he had to do was do what he said he was going to do, and he never did. I think he has some type of habit. I don't know what's going on with him, but that's just his own personal life. But as of right now, I can allow him time to move out of the property, but he's got to go. He's been staying there for years and hasn't paid a cent since the beginning. He paid $1,000, and that's when we were supposed to start the deal. And we got dates to that also. So it's been about 3 years. This guy's paid nothing. So whatever he says he's putting to the house work-wise, I mean, it's well over that what we should have been getting for rent or the house just being in our possession, period. So, you know, I have nothing else to say about the situation. And I felt like I was taken advantage of and screwed over. And then he basically tried to force me to sell him the house for a certain price at the end of the day. So
And
that's
Judge,
why this
Kind of brief.
just to add, I'm sorry, Judge, just to add to that, this court doesn't have jurisdiction to quiet title. That would have to be done in the circuit court. And any claims for unjust enrichment, that can come in a separate, that's a separate issue that can come in a different case or a subsequent case.
Your Honor, briefly.
Sure.
I think the plaintiff has made the best case for why this case should be set over for trial, so we can have discovery and get at all the voluminous documents that he says he has that prove exactly his point. Yes, I'd like to see the emails that he has referenced.
Show them to you right now. There's no emails. It was all text. It was texts, me trying to get him.
May I proceed without being interrupted by plaintiff?
Mr. Johnson, please mute yourself.
Yeah. Your Honor, the time for discovery isn't during the trial or during the hearing here. And looking at his phone, I'm sorry, not able to see his phone over the screen. So I would just ask for a reasonable adjournment time so that we could get a response from Mr. Bajani to my pleadings and have some discovery so we can get to the bottom of this. The plaintiff did indicate that there was a verbal agreement for work to be done and some money, and that $1,000 was paid up front. We do know that the property was purchased at tax auction for $2,199, and I think it's not unfair to take judicial notice that properties like that are generally very challenged. Defendant's position is that it was open to trespass and no windows, no doors, etc. And he has taken care of that, including putting in a furnace, hot water heater, and other expensive items, relying on the deal that they had. So I think there is a legal basis here, and certainly equity and fairness screams for at least setting this over for trial. If not removing, as Mr. Bajani indicated, yes, by title would have to be in circuit court. And that's one of the requests that we've made.
I think I might just remove this initially. I want you all to go on, I think I'm going, okay, the court's going to remove this too. This is a termination of tenancy case. If I order discovery and I order more time, it's going to delay this issue, and you all still won't have, you're going to have the same argument at the end of our resolution. So that's what I think is going to happen. Now, discovery, whatever items you're looking for, I'm going to remove this to circuit court. You all
Thank
can
you.
That's your title issue. But in the meantime, well, if it's removed, it's out of my jurisdiction. So,
Judge, I don't believe this court has the authority to forcibly move a court up to the circuit court. It can be sent down, I know that, but I don't think it can go up.
well, I don't have authority to address an issue and issues of ownership and issues with this land contract have been presented, and it's not a land contract forfeiture. So we're going to be analyzing contracts, analyzing text messages, see if they comport with or comply with the statute of frauds. You say they don't. Mr. Phillips says they do. So that's a title issue.
And the court removes cases like this all the time, Your Honor.
Yeah,
This court, now I'm not saying Your Honor, but.
Oh, yeah, but yeah, exactly. So how much time is being offered?
Mr. Lucas, you can answer that.
Yes, how much time does he need? I mean, it wasn't a right away that I needed him out tomorrow or anything like that, but he has to know that it's not, he acts like the property is his, and it's not. So he has to know that it's not, and I will allow him a reasonable amount of time. You can ask him how much time he needs, and I probably can negotiate off of that.
Your Honor, if I may, substantial amount of work and money have been put into this by the defendant. He's ran into some medical issues in the last couple of years. Moving would be very difficult, but even beyond that, I mean, he has paid for this home through his labor and his dollars. And
right, but not through the normal way of paying. I understand your argument. Understood. He's probably got a ton of sweat equity in there. They probably have text messages and agreements and disagreements. I get both sides, but this can't. There's an advantage to adjourning this for trial that will put the plaintiff at some type of loss just with time, sensibly. With time, maybe it's extra utilities that are being paid by your guy or the landlord or property taxes. So I'm just want to stop, not necessarily stop the bleeding, because it may be a benefit to him being in that home, which I'm sure it is to a certain extent. But like you said, he's treating it as if it's his home. And technically, or based on the information I have, he doesn't necessarily own it. So I can set this for another hearing in the digital era within the next week, just to give people time to review the answer. And if this is the decision, and if this is what you all want to do, then I'll remove it to circuit court. I know, Mr. Bajani, you want a judgment today, and Mr. Attorney Phillips, you want discovery. So why don't you all talk today? But I'm going to adjourn this matter to May 31st. So you all don't have to come back in person. and then we can address this, and we'll get a resolution at next hearing. At one time to look at the pleadings and just make sure I'm not overlooking anything. And if you all, Mr. Bajani, if you want to send something as well, just CC both sides, and we'll look at it before the next hearing. And if you all need more issues are presented at that point, we'll address those issues. But right now, I'm leaning toward leaving this up to circuit court to decide the title issue. So we'll do an adjournment to May 31st. May 30th, excuse me. No, which day do you need, Attorney Phillips? Is it May 31st?
Your Honor, 31st is fine.
Okay, May 31st at, let's do it 10:30. That'll give me time to look at what was sent over today, and then it doesn't give you too much of a delay on the plaintiff side. If this is truly a title issue, and we'll address it. But I don't want to make a decision on that right now. So.
Fair enough.
Yes,
Thank you, Your Honor.
Thank you.
See you all next week. And thank you for your testimony.
You can log on.
Thank you.
Mr. Lewis, hang on. We're going to go to breakout room.
Okay.
All right. Let's get back. Mr. Regan.
Yes, Your Honor. I believe we are ready with case ending in 754.
Excuse me, John. Yeah, hold on one second. I have an in-person.
I'm not upset up.
Hello?
All right, Mr. Regan, what's that case number?
It is case ending in 754.
Case number 2334-6754, Carmen McCoy versus Bruce Dinkins.
Good morning, Your Honor. Eleanor Karagian with UCHC P86696 on behalf of Mr. Bruce Dinkins, who is present in the gallery. Mr. Dinkins, can you please state your name for the record?
Bruce Dinkins.
And I believe the plaintiff, Carmen McCoy, is in the gallery as well.
Oh, I'm sorry, Miss. Okay, and Ms. McCoy.
Yes, Your Honor.
Just how much I'm needing next payment then.
Can you state your name for the record?
7 in 2 weeks.
Carmen McCoy.
And it's all for.
All right, and were parties able to work out some type of resolution?
Your Honor, we are under the belief that the plaintiff does not have standing to remove the defendant from the home and that she is not the property owner.
All right. Okay, so, Ms. McCoy,
Yes, Your Honor.
are you the property owner? Let's get this file.
I am the personal representative of the estate.
And have you been assigned personal representative through the probate court?
Yes, Your Honor.
Okay, and whose estate are you personal representative of?
Our mother, Nidra L. Dinkins.
All right, counsel, do you want to review those? Are you still maintaining your stance, counsel?
Yes, Your Honor, the last recorded deed is from 1969. And we don't have any indication. We do know that she is the personal representative, but we do not have any indication that she has ownership over the home at this point.
And that was the last deed in Nidra Dinkins' name?
It was under David Dinkins and Nidra Dinkins.
Okay, with rights to survivorship?
I am not sure.
Okay, so I'll allow, the notice is proper on this, where it states the estate of Nidra Dinkins. Now, the complaint, the summons and complaint state Carmen J. McCoy.
Carmen T. McCoy.
Carmen T. McCoy.
Yes, Your Honor, and as this was not brought in the name of the estate, it should be dismissed.
I can allow her to amend it, counsel. I can allow her to amend the pleadings. As long as the notice is proper, which is what I'm concerned about. Because if the notice wasn't proper, then we'll have a huge issue. And parties are here. So, Ms. McCoy, are you requesting to amend this?
Yeah. I'm not sure what that means. Amending. Can you explain to me what that means?
The owner of the property is the estate. You put the plaintiff as Ms. McCoy. So.
Your Honor, I would also like to mention that since this case should be in the name of the estate, Ms. McCoy is unable to represent herself in this matter. She would need an attorney.
And personal representative don't have the capacity to represent an estate?
That was my belief, Your Honor.
Okay. Do you have personal representative papers, Ms. McCoy?
Yes. Yes, Your Honor.
Okay. All right, and can you present that? I'm gonna put you all in the breakout room. Can you exchange that information with counsel, and then I'll recall this case and see if we can move forward today. I at least want to, I'll see, I'll make sure. It's my belief that personal representatives can represent an estate.
Your Honor, unless she is an attorney, she cannot.
All right, cool. You have any authority on that?
Yes, give me one moment.
Okay, I'll recall this case and I'll put you all in the breakout room. Just let me know when you're.
Thank you, Your Honor.
Well.
It shows.
You're trying to get me to have a case on my file. I ain't never had a file or case or nothing. Y'all
Mhm.
I don't know what happened.
You have to pay $467 a piece.
Hello? 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 Yes.
We're here, you guys. The court will be with you
All
shortly.
right, everyone, please just, thank you, Madam Clerk. Thank you, Madam Court Reporter. All right, Ms. Trumbull, how can we help you?
Gave me 30, I'm new. You not do it? Judge, can you hear me?
Yes, ma'am.
He gave me 30 days.
Judge, I have a case ready with Ms. Trimble, if you're ready.
Okay.
207.
Calling case number 2334-7207, Woodbridge Senior Village versus Gwendolyn Trumbull.
Good morning, Joe Horka, P75969 on behalf of the plaintiff.
Make a payment today.
Tomorrow, right?
Ms. Trumbull, can you state your name one more time?
My name is Gwendolyn True. I live in the Woodbridge Senior Village, 3701 Miracles Boulevard, apartment 1101, building 502K. The management is under Miss Dorsey right now, back and forth management. Management now, Dorsey.
Judge, I've spoken with the defendant in the breakout room. We'd like to do a conditional dismissal with box 4B checked June 26th as the pay or move date. The current balance on the account is $4,852, including the court costs.
Now, I wanted to ask you for representing me. If that is not enough time for me, the 26th, is that all the city of Detroit can do for me?
Ms. I represent Woodbridge. I don't know if the city of Detroit can help you out with other resources, but my authority is for 30 days.
All right.
And Ms. Trumbull,
yes,
there
yes,
are available. So what's the move out date, Mr. Horton?
June the 26th, Your Honor.
If
So
I'm
June,
to be,
go ahead. What'd you say?
if I'm to still be there, I know eviction will come and they will put a lock on the door. I'm to turn the keys in. The management is waiting for me to turn the keys in. After that date, say I'm still on their property. I'm just saying. I tend to care for the seniors in that area and in that building. Say I do turn the keys in and still on the property. I'm not far from the.
You won't be in trouble. You can come in there as a guest, but you just can't occupy the premises and live there and reside. So once you turn your keys in, if you have buddies up there, if you have
no
big deal or whatever you want to do, you just have to have. You just have to
cleaned
have
out. Yeah. Well, thank you, Your Honor.
So you're welcome. It's conditional dismissal. So this case will be dismissed if you vacate by June 26, 2023, or if you pay $4,852 by June 26, 2023. But in the event neither of those happen, box 4B is checked, which says that a judgment and a writ of eviction can enter at the same time.
Okay. I think I understand that. Yeah.
Okay.
What's a writ, Your Honor?
Writ of eviction. That would be the writ means order, so an order of eviction from the court. So does Mr. Horka have permission to sign your name on the conditional dismissal?
Are you talking to me, Your Honor?
Yes, ma'am.
I didn't hear you.
Do you give the attorney, Mr. Horka, permission to sign your name on the conditional dismissal that we just discussed?
Yes, I think you did. Are you there? Is he there?
Yeah, he's
Yeah, we
there.
get-
He just, as long as you say yes, he'll sign.
Yes, yes, I approved it. Well, you
Okay.
approved it, yes, I do.
Well, good luck, Ms. Trumbull. Thank you for your patience.
Thank you, and wish me luck on the city of Detroit. I wish to continue my mission with the seniors, hopeless and the hungry and the homeless out there. Have a great day.
All right, well, that's a good mission. Good luck with that mission, Ms. Trumbull. Have a great
Thank
day.
you very much. You too.
Thank you. All right, Attorney Flesling, you're looking for a date?
Yes, Your Honor.
Okay. How far out? How close, how far?
Was Mr. Gross still here?
I am.
Mr. Gross, how much, what time, what's your timing on this?
Just a
Your
couple
Honor, he's
weeks.
the new counsel on this matter. We've got to get documents to him and give him a chance to get up to speed, so I don't know how long he needs.
Fair enough. I didn't know if you'll be ready today, but I figured I would see what happened, but not a problem. What's the, how much?
A couple weeks would be fine, Your Honor. I don't know how far out this court is setting dates.
A couple weeks is good.
All right, let's see. Let's go June. June 7th? Is that far out enough?
That sounds good, Judge.
Should be sufficient, yes, Your Honor.
Okay. June 7th, I'll see you all back at 10 a.m.
Very good. Thank you, Your Honor.
Thanks, Judge.
You're welcome. All right. I need to put some more names because we're into triple default territory. Everything is eligible for default, and if it's not eligible, then we should have some negotiations done or pending. So let's see, Mr. Christensen, Mr. Saman, and then Mr. Bajani, and then Mr. D. And then I'll get to the non-attorneys after that. Mr. Hunt and Mr. Baker, Ms. Baker. Okay.
Good morning, Your Honor. Ben Christensen. I'm just checking in on, well, I'd like to hopefully call the case if that's available, if that's doable, but it's a case ending in 683 Silver Capital Group versus Lori Jones that I believe was scheduled at 10 a.m. today.
Yes, sir. Is Lori Jones here?
Yes, Your Honor. Miss Jones?
Okay.
Yes.
And this is with Joe Horka.
Yes, sir. Let's see. Attorney Horka left out.
It looks like he's in the gallery.
All right.
He may have had to step away from to another courtroom. I'm waiting for him on a case as well.
Okay, so keep an eye out, Attorney Christensen. I have you marked here. Lori Jones checked in. So when you're ready, you know the best way to get my attention. So.
Okay, thank you, Your Honor.
Well, Mr. Saman and then Mr. Bajani. I think that was the order. Counsel. Mr. Saman, what do we have?
Yes, Your Honor, we're ready on case ending in 725. That's with Miss Robinson.
Calling case number 2334672 Clear Sky Realty LLC versus Lana Robinson.
Yes, good morning, Your Honor. William Saman on behalf of the plaintiff, 80352.
Thank you. Is Lana Robinson here?
Yes, I'm here.
Okay, can you state your name for the record?
Lena Robinson.
Thank you, Ms. Robinson. Were parties able to work something out?
Yes, Judge, we were. The parties had a chance to speak, and we've agreed that the plaintiffs will, the defendants will pay the amount of $1,735. That's including $160 core cost, the rest being rent, by June 26, 2023, or writ may issue thereafter. This will be a judgment by hearing, Your Honor, against all occupants.
The judgment by hearing is the amount 1,575.
1,575, yes, plus $160 in court costs for a total of 1,735.
1,735, and there's a removal of Ms. Robinson's name, and this will be in all occupants.
Correct.
Hopefully that will in the future. This will be a judgment by hearing where all occupants must pay the sum of $1,735 by June 26, 2023. If that doesn't occur, a writ of eviction may issue.
Yep. Thank you, Judge.
You are welcome. Good luck, Ms. Robinson.
Thank you.
Welcome. You're free to leave, and you may get something in the mail within the next week or so. Reflecting this.
Okay.
All right.
All right.
Is Donna Higgs here?
Yeah, hold on.
All right, that's it.
Donna Higgs?
Let's go. Yeah. What you gonna do?
Okay. Did someone respond to Donna Higgs? All right. No Donna Higgs. All right. Who else has their hand up?
Ms. Baker.
Mr. Deekland. I know I'm getting to attorneys first because they have more cases than you all. Good morning, Mr. Deekland.
Your Honor, I have two cases that are ready with Attorney Bijani. Oh, go ahead.
On case number 23345636, Mutual Property Management versus Chanel Jefferson.
Good morning, Judge Ely Bijani, P74626, on behalf of the plaintiff.
Good morning, Your Honor. Benjamin Dietland, P number 85412, on behalf of Miss Jefferson.
Thank you. All right, the parties able to work out an agreement on. Is Ms. Jefferson here? Ms. Jefferson, are you present? All right. Counsel.
Yes, Your Honor. We have arrived at a conditional dismissal in this matter. The terms of which are that there's $1,632 owing through May 31st, and defendant will pay her normal rent plus $100 a month until she's caught up, with any payments being able to be made in advance. 4B is checked on this, and conditional dismissal has been faxed to the court.
All right, court will approve. Court is satisfied with the terms set forth on the record. 4B, I don't know if Ms. Jefferson is here, but if you're here, 4B means that, well, this is already signed by all parties, counsel?
Yes, Your Honor.
All right, the court will enter this agreement. Thank you.
Thank you, Judge.
5636. Let's call case number 23345638, Mutual Property Management versus Levette Johnson.
Good morning, Judge Ely Bijani, P74626, for the plaintiff.
Good morning, Your Honor. Benjamin Dietland, P number 85412, on behalf of Miss Johnson, who I believe I see present on a telephone.
Yes, I'm here.
All right, good morning, Ms. Johnson.
Good morning.
All right, have parties come up with the resolution?
Yes, Your Honor. We have faxed a conditional dismissal to the court, which indicates that defendant is to vacate the property by June 26, 2023 as a voluntary move with no findings against either party. Defendant will vacate as a tenant in good standing. 4B is checked.
Is this a termination of tenancy?
It's
Yes,
not.
I believe, or no, it is not, Your Honor.
Okay, and okay, you said 4B is checked,
4B is checked.
and what's the amount to redeem? I missed it.
Your Honor, I don't believe there is an amount to redeem listed on the CD. It's a move out CD.
Okay, so are we converting it to termination of tenancy?
I suppose that would be the thought, Attorney Vijani. I don't know if you're agreeing to that.
Well, Judge, yeah, the CD that we already signed and sent, it pretty much implies that we are converting to a termination.
Okay. So this will be converted to a termination, and the language is on the CD, the voluntary move without findings of any party.
Yes, Your Honor.
All right, the court is satisfied. Did I miss anything?
No, I do not believe so.
Okay, all right. Thank you, counselors, and we'll sign that as soon as possible. I'll try to sign it today, the rest of these documents.
Yes, Judge, thank you.
Thank you all.
Thank you. On 1 second, I have in-person matter.
P83143 for the plaintiff.
Attorney Coleman?
Ready, Your Honor. Lockhart for Coleman.
Man, Attorney Coleman looks different.
Much prettier.
Yeah, much prettier. That's what I was thinking. Calling case number 233401113. This is MLC Rentals LLC versus Lene Evans.
Judge, please court Steve Lockhart, P32090, standing in for plaintiff's counsel of record, Frederick Coleman. We'd be seeking a default unless there is a Lene Evans or any occupants of 15268 Lappin in the city of Detroit. I don't see present on the Zoom. I'd like to proceed. I'd be asking for a default if we have no one present.
Okay. Is there a Lene Evans? Does anyone reside at 15268 Latin? If you do, hit *6. All right, counsel, defendant failed to appear, default judgment is granted. Is the amount to redeem still 2495?
Negative, Your Honor. The amount is $2,145. That includes $395 costs. This is a second hearing after prior Judge Kennedy authorized an order for alternate service. We have had attachment and have sent out certified and first-class mail. We do not yet have the green return card at this moment. We would submit that that's adequate for our request in support of a default judgment.
I do have proof of service in the file. This is a land contract.
Yes, Judge, and more than 50% of the principal balance has been paid, so we'd be asking a 6-month redemption, which looks like it might be Monday, November 27, after the Thanksgiving holiday.
Thanksgiving. All right. That sounds accurate, counsel. And just submit the green card when you get it. There's plenty of time to redeem, so the court is comfortable with entering this. And this is a land contract forfeiture default judgment, whereas alternate service was granted in the previous hearing. Parties have executed that alternate service, and more than half of the land contract is paid. So defendant will be entitled to 180 days to redeem this property, and that 180 days amounts to November 27th, 2023. So defendant must make that payment of $21.45 by November 27th, 2023, or else the property will, a writ of eviction could be filed.
Thank you so much, Your Honor.
You're welcome. Thank you. Have a great day.
Same.
Make sure you relay that message.
Done.
All right, thank you. All right, okay, Ms. Becker,
Yes, hello.
how you doing? You had your hand up?
Yeah, this isn't Miss Baker. This is her daughter-in-law. She's sitting on the side of me. We was waiting on the attorney to come back. I guess they're waiting on an email or something from the rental company or something like that. But we've been sitting here since about 9 o'clock. So I'm just trying to figure out what's going on because my phone is getting ready to die. And I do have other things that I need to do.
Oh, okay. Well, Ms. Baker, I suggest you charge your phone. Whatever attorney you have, just communicate to your attorney what's going on, and then they'll communicate to the other attorney, and then those attorneys will communicate to the judge. So just
Okay,
try.
well, said that she was going into another courtroom, so I don't know what's going on.
I don't know who your attorney is, and I don't know who your attorney is. Make sure you keep your phone charged. That's most important.
So do she just have to sit here? Cause she's on my phone, not her phone.
Cause I don't have the kind of phone to do put through.
Okay.
And I've been sitting with her since 9 o'clock.
Okay. Well,
Her name's Laura.
I can call your case right now but you have an attorney, so I would be improper calling your case without your attorney present. Because you have
Well,
representation.
I'm just trying to figure out, do we see her until she come back or what's going on? Cause
She told
I
me
don't
in
know.
an hour she's back with her.
Wait for her to come back.
Okay.
You have to wait for her to come back, or maybe you can call in you all can, use the dial-in number, and then you can use your phone, and then you can get your phone back. But that's the only solution I can see, other than just waiting it out like everyone else in
I
here.
mean, to be honest, she wants to pay whatever she has to pay right now. So if you want to call the case and go ahead, we already know what's going on. So she said it's gonna be some type of money she's gonna have to pay. So, I mean, we kind of already know what's going on. So, I mean,
I wouldn't know the total amount, but I'm gonna have to send in.
All right, Mr. Horka, is this your case?
Yes, it is, Your
All right. Are you in another hearing?
I was in a breakout room, but I am completed with that. I am ready to call it if you are.
All righty. What's the case number?
For Catherine Baker, Your Honor, 705.
Okay.
Aye.
Calling case number 2334-6705, Investors Property Management versus Catherine Baker and all occupants.
Morning,
Yes.
Joe. P75969 appearing for the plaintiff.
Well,
Thank
Your
you.
Honor, I'm sorry to interrupt. This is Miranda with the Housing Coalition. Attorney Lauren Lemonius is on this case. I've just sent her a message and she's on her way into the courtroom.
Okay, they said that they didn't want the attorney, so, all right. I'll just wait, but please, I'm not answering any more requests from anybody who's not an attorney. You just set a policy right now. Is this? Mr. Fawaz,
Good morning, Judge.
good morning. All right, are you ready on 7258?
Yes, Judge.
All right, calling case number 2334-7258. This is KPM Detroit LLC versus Jake Cosgrove and Creona Crenshaw.
Yusuf Wazmi, have the plaintiff, P number 83664.
All right, Ms. Crenshaw.
Yes, Your Honor.
Good morning. You are represented by counsel, correct? Or is that advice only? Was it advice only?
They told me since I called yesterday that that they wasn't going to be able to get somebody to counsel me right now. So they told me they would call me back like Monday or Tuesday or to adjourn it.
Okay. Now, were you able to work out something with Mr. Fawaz?
Huh?
We haven't spoken.
Okay. Why don't you all, as a practical matter, do you want to speak to Mr. Fawaz? He's here. You want to see if you can figure it out?
Could we do this, Judge? Could we could we set a could we adjourn today's date and then put us in a breakout room? Maybe we could figure something out.
Let's do that. And then that'll give you time to get counsel. And then in the meantime, if you all have a good offer on the table, then you can run it past your counsel, Ms. Crenshaw. How does that sound?
Okay, that's fine.
All right, but the next time we come back, how much time do you need? Because June 5th, we'll be in person.
Before June 5th, if possible.
All right, June 1st, you think can
That works
you
for
all
me,
come for June 1st?
Yeah, that works with me.
All right, we'll come back at June 1st at 9 a.m.
So that's the next court hearing is at June 1st?
Yes, and to make this worth both parties' while and to push the case along, I'm going to invite both of you all into a breakout room. Make sure you get those co-host privileges, Mr. Fawaz, so you can get out.
Thank you, Judge.
And Crenshaw, I'm going to give you co-host privileges too, so you don't get stuck in the breakout room.
Okay.
That'll just let. But anyway, this case is concluded. However, I'm going to invite you all to have a conversation, and he knows you're seeking counsel, so he won't. So nothing will happen today anyway, but you all can talk, and then maybe it's some progress made. So,
Okay.
Thanks, Judge.
You're You're welcome. So you are free to go after you all meet Ms. Crenshaw. You don't have to talk to me.
Okay. All
You'll
right,
get
Your Honor.
All right, good luck. Have a great day.
You too.
All right, Mr. Christensen and Ms. Fisher. Well, Ms. Fisher and Mr. Christensen.
So do I just press join breakout room?
Yeah, just join, quick press join breakout room.
Okay.
Yeah. All right. Ms. Fisher.
Yes, Your Honor. I think Attorney Horker, are you ready?
No, I'm not ready on that case, Ms. Fisher.
Okay, so we can pass, Your Honor.
Okay. All right, is Hassan Ali here? Sure, let's see.
Yes.
All right, Hassan Ali, is Rosalind Harris Gates here? Yeah, Rosalind Harris Gates. Have you all had an opportunity to speak?
No.
All right. And Ms. Gates, are you connected? You're not connected to audio. So Mr. Ali, do you have Ms. Gates' number?
We tried calling since November and been trying to get in touch with her and haven't had no success.
Okay. All right. So I don't know how we communicate to her without audio work. So let's see what we can do. Ms. Gates, I'm going to remove you. I can't default her, Mr. Ali. I'm going to remove her to try to get her audio work.
Okay.
I don't know if that's going to work. Ms. Gates, can you hear me? You can hear me? Can you read the chat? All right, she can read the chat. All right, Mr. Ali, I'm going to send you a chat so you can give me your telephone number. Once you give me your telephone number, I'm going to send it to her. So then she can call you, and then if you all work something out, that's better. If not, then at least we'll get her on the line. So if she falls off, we can contact her. That's my biggest concern. So
okay.
I can't figure out. Oh, I can't message you. You're on the phone. What's your telephone number?
313-412-9164.
You said 7164?
No, 313-412-9164.
9164. All right. Let's see. Miss Harris Gates, did you get that? All right. It's 313-412-6164.
No, 9164.
I'm sorry, 9164. 412-9164. Nod your head, Ms. Gates, Harris Gates, if you have the number.
Okay, yep, she's calling me now.
Okay, all right. And if you all fall off, I'll just let you all back in.
Okay, thank you.
You're welcome. One way to do it. Anthony Iman. Anthony Iman or Anthony Iman?
Yes, I'm here, Judge.
All right. Was it Inman?
Yes, it is.
Okay, they had a clerical error. Is Demia McKissick here? Yep. And have you spoke to each other?
No, we haven't.
You have a resolution?
I do. Pay up or move.
Do you, all right, calling case number CR436 Anthony Inman versus Demia McKissick.
Yes,
Can you state your name for the record?
my name is Anthony Inman.
Thank you. Ms. McKissick, can you state your name for the record?
Demia McKissick.
All right, and Mr. Inman, are you the owner of the property located on Springfield at 5856?
Yes, sir.
All right, and are you reside at that property, Ms. McKissick?
Yes.
All right, and what is the total amount of rent that's currently owed?
$1,700.
Could you repeat that one more time?
$1,700.
All right, $1,700. Ms. McKissick,
Yes.
do you know when you can pay this $1,700?
Yes, he can just give me 30 days. I haven't paid all up. If he can give me 30 days, I'll pay it all up. Haven't paid up.
And Your Honor, I have no problem with that. I will give her 30 days.
All right, so this is what we're gonna do. And there's another consideration that is totally up to you, Mr. Inman. But there is we do have some housing issues. So we can either enter a consent judgment, or I could do a judgment by hearing where I could remove her name personally and it'll be an all occupants judgment.
I can do that.
Okay.
I can do that
All
too. Yes. Yes, I can do that.
So we'll do a judgment by hearing where all occupants must pay $1,700 by June 20. It'd be June 26th. That's the first business day.
Okay.
Hold on. I'm sorry. 25th. So it's 31 days. So 24th falls on a Saturday. So June 26th. So all occupants, a total of $1,700 by June 26th, 2023. Or a writ of eviction can be filed after that date.
Okay.
All right. I want to thank the landlord too, but I'll leave that up to you. Thank you, parties, for working that out, and good luck to both of you all.
Thank you. You have a good day, Judge.
All right, you too. You all have a great day. Ms. Trumbull, I see your hand up.
Okay.
My goal is, all right, and what case are you on, Ms. Trumbull?
Okay, can you hear me?
I can hear you loud and clear.
I have 2 court cases. I was just in a breakout room and they think that it is on June 1st, and I just wanted to confirm. Because I've been sitting here for a long time and they said it's not today.
Okay, yes. I don't see it on the case. I don't see it on the docket today. What's your full name? What's your case number?
The case number is 233-47205 and 7204.
June 1st at 10. June 1st at 10. All right, is she in here? Yeah, you're probably. Did you go to hearing number 1 already?
Yes, with Judge Kennedy.
Okay, yeah. So you're in here June 1st.
Okay, and that's at 10 a.m.
So you're well aware of how the process will go.
Yeah.
And see what's going on. So I'll see you back on. And good luck. Enjoy your day.
You too. Thank you.
You're welcome. Is Tommy Rowan here? And then Dorothy Williamson and Curtis Samuel.
Yep, 1.
It's, good morning, Ms. Williams.
Good morning, Your Honor.
Good morning. Thank you for your patience. Curtis Samuels is being represented by Mr. Santiago, I believe. Have you had the opportunity to speak to Mr. Santiago?
No, I have not, Your Honor.
Okay, can someone confirm if,
I'm sorry, Judge, I just heard my name.
are you representing Curtis Samuels?
I am not, Judge. I have not spoken to Mr. Samuels. I don't know if anyone else from either UCT or MLS has spoken to him.
Someone requested the copy, scanned copy. Was it Ms. Lamont?
Not me, but I can find out who it was.
We sent an invite for him to be in the breakout room and he never responded, so.
I believe he dropped off, Judge, at some point.
Curtis Samuels is here.
I'm still here. He's still here holding strong.
Yeah, I'm still here, Judge.
All right. So Ms. Williamson and Mr. Samuels, do you all want to have a conversation?
Yes, we do.
Well, if he does, I'm fine with that. I mean, I just want to get this going, but if that's what he wants to do, I would never want to deny that of him.
All right, that sounds pretty reasonable.
Yeah.
All right. Well, this is what, before I put you in the breakout room, before I invite you to the breakout room. If he asks for counsel, just notify us and bring him back out because
I'm gonna need a counsel, Judge.
Okay. Okay, and we may go to, I'm gonna give both of you all breakout privileges because you can get stuck in the breakout room if you don't have them. So don't abuse
Your Honor,
your
we do have counsel available to speak with him if you would like.
Yes.
Okay. Okay, I thought you said you do not need counsel.
No, I said I do need counsel, you Judge.
All right, now, do you have a problem with Ms. Williamson? Well, Ms. Williamson is here too, and it may be helpful to speak to her as well, but I'll leave that up to the lawyers and the way they want to go about discussing it. So I'll invite you into a breakout room with Ms. Luan, or I'll just put you in, I'll invite you into a breakout room, Mr. Samuels, and someone will speak to you.
Yeah, someone will join.
Yeah, why don't you all facilitate it, because I think he's already in an old room, and he's got breakout privileges, so he's all right. So I'll leave it up to you all. This is the issue. Go ahead. Oh, yeah, it's okay. Okay. Yeah, it's okay. He said, I guess, here you see. Oh, tell him. Jack. Mr. Jackson. He's over the phone. Oh, something called the phone? Okay. Yeah. All right. Okay, we're approaching 12 o'clock. Attorney Adam, you have something in here this morning?
Yes, I have. Good morning, Judge Sabree. My name is James. Yes, I believe I have a defendant's motion and I have a pending writ on case number 401 at 1025.
What's the case number? Let me make sure you're in the right.
22393-401.
Yes. 22393-401.
It might be McClinton.
I think it's in Chairman Millicent's courtroom, counsel. Can you read? All right. Good morning, Judge Sabree.
Counsel, this case is in courtroom 535.
Okay, sorry. Thank you.
Yeah, so this is what happened. The judgment was set to, she was supposed to move out a week ago on the previous judgment. And the judgment didn't allow her enough time to notice. So I had the plaintiff come up and we basically gave her another 7 days. Gave her another 7 days to make sure she got it. I said, come up and visit your judge. Your writ. So you already paid for the writ, but you had to wait a little longer. So today was the day. Now, Madam Clerk came up from 2 and told me that they're supposed to All right. Most of you all who are here have Attorney Cox as the landlord's attorney. There's 6 landlord-tenant courtrooms. So there's always some type of delay because everyone can't be everywhere at one time. I'm saying that because we're approaching 12 o'clock. We've all been here all morning, but cases aren't going to magically get called. So we still, Attorney Horker, are you here? Or are you still in another courtroom? I know maybe in another hearing. So Attorney Horker is probably in another hearing. Several of the attorneys who are representing you all have to talk to Mr. Horker. After they talk to Mr. Horker is going to talk, or either party let the court know they're ready. This is what we've been doing all morning. I have to give my staff an hour break between the hours of 12 and 2. And we have a 1:30 case. So I need to be back by 1:30. So while parties are still negotiating, and I tried to get all the improper parties out of here that I could, and it looks like everything else is dependent on attorneys being able to talk and communicate, with the exception of you, Ms. Williams. And I think the other side has an attorney on that. So we're going to take this time. We're going to take an hour. So if you all have to go to lunch, do whatever you have to do, we're going to give it an hour, because there's no need to wait and work until this 12 o'clock and results don't come, and then my staff doesn't have a break, and I have you all waiting for no reason to. So you need to make a phone call, need to use the bathroom, need to go do whatever you have to do. We'll be back at, really, I'll come back at 1. Madam Court Reporter is at 1:15. We'll come back at 1:15. We have a 1:30 docket, but you all from the morning docket, so we're not gonna make you wait till 1:30, but an hour is an hour, so 1:15. Okay. A little more than an hour, but I'll see you all back at 1:15. And if someone has anything ready right now, or has to go to work, or agrees to something and gives their attorney consent to put it on the record, that's fine. But if we need to talk to you and you're not here, that can pose a problem. So I don't want that to be you waited all day long. So.
Your Honor,
Hi, my name is Kimberly Fantroy. And you told us not to speak unless we were an attorney, but I did already make an agreement. I'm just not sure.
Troy, I'll take you to a breakout room when we can talk, okay? This is Suzanne Lewan, the attorney you spoke with. Let me pull you into a breakout room.
Okay.
Because I cannot call the case. Plaintiff's attorney here, Mr. Horka is in another courtroom, and you
I'm
are
present.
Oh, you okay? You're present? All right. Okay. If you're present, let's knock out whatever you have ready, and then we'll go to break. That way we can get something.
Your Honor, this is Hassan Ali.
Mr. Ali.
Yes, I spoke to Mrs. Harris, and we came to agreement. So is it possible we can adjourn it for 30, see if we can work something out?
Okay. Yeah, I'll give you an adjournment. 30 days, you all have to be in person. Know that, right?
Okay.
And Ms. Gates, do you have an issue coming in person? Do you have any issues coming in person, Ms. Gates? You can just nod or shake your head. All right, I can't determine what that is, but 30 days will get us to
okay. We appreciate
it. Let's do June 21st.
June 21st?
June 21st. It's not quite 30 days, but it's close.
Okay, appreciate it.
And Ms. Harris Gates, can you hear me? Can you hear me? Okay, we'll be back. We're gonna adjourn the case to June 21st at 9:00 a.m., okay? And then it'll be in person in 36th District. All right, I'll see you down here June 21st. You too, Mr. Ali.
Okay, thank you.
Your Honor, what's
All
the
right.
number for that?
That is 2334-7246, Hassan Ali versus Rosalind Harris Gates. Parties are free to leave, and this matter is adjourned to June 21st at 9 a.m. All right, Mr. Horka, I'm ready for you. Mr. Wan.
We have a case together. Are you ready on that one, Joe?
Sure.
7222.
Calling case number 2334-7222, CEGFRF owner LLC versus Antoine and Kimberly Fantroy.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of defendant Kimberly Fantroy, who is with us in the courtroom. Ms. Fantroy, will you unmute and state your name for the record, please?
Kimberly Fantroy.
Thank
you, Ms. Fantroy. All right. What are the terms of the agreement?
And the parties would like to submit a conditional dismissal, box 4B checked June 25th.
All right, and is there an amount to be paid?
I believe it's 340413. Yeah.
That's what I have.
All right, $3,404.13 must be paid, or party must vacate by June 25th, or writ of eviction and an order of eviction may issue after that date. The judgment and the order can issue based on box 4B being checked. Both can be issued without us coming back to court. where the parties pay 3404.13 or vacate by June 25th, this matter is dismissed. All right, thank you, parties. Good luck, Van Troyes, and you are free to leave.
Thank you, Your Honor. Ms. Fantroy, you are free to sign off the court.
Okay, have a great day. Thanks. Bye-bye.
Thank you.
And all right, what else do we have? Attorney Fisher, do you have a resolution?
I don't think we have a resolution, and I don't know how we're going to reach one. I have, this is Kokanagar, Amani.
Okay. All right, let's hold off on this one. This may be a afternoon matter.
Okay.
I don't want hearings before lunch because
Okay. That's fine, Your Honor.
About 1:30, no problem. And Mr. Christensen?
Yes, Your Honor. For the matter, Silver Capital Group LLC versus Lori Jones, 683.
Calling case number 2334-6683, Silver Capital Group LLC versus Lori Jones and all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Good afternoon, Your Honor. Ben Christensen, P86268 on behalf of the defendant, Ms. Jones. Ms. Jones, could you please state your name for the record?
Lori Jones Little.
Thank you, Ms. Jones. Were parties able to work out a resolution?
Your Honor, we're just, defense is requesting an adjournment. 30 days would be ideal. We need to see the HAP contract for this Section 8 tenant. We, at this point, dispute the late fees, which are $150 a month. She is working on third-party payments. There's a whole issue with the the subsidy provider falling off on their payments, but they're back on track. And she's working, so we just need to work on a third-party payment that she is working on right now with the Detroit Housing and Revitalization Department of Detroit. So we think a 30-day adjournment, we should have everything sorted. And that would give, tenant enough time to figure everything out, and for me and the opposing counsel to continue to work on negotiations.
And until Attorney Christensen, I would be more comfortable with a 2-week adjournment on this. The balance is almost $6,000. There is a money judgment with personal service involved. The balance continues to grow, and there really isn't a plan for direct payment unless this third-party payment comes through. So to protect my client's interest, I would ask for a 2-week adjournment on this.
Well, if Your Honor, if I may, 2 days ago, I asked for a ledger and it was at $8,342. Although on the 16th, the Section 8 made some payments. The ledger didn't reflect that, so they were trying to move forward on that money judgment when, in fact, now it's $5,678. So if anything, the ledger's going down. We're sorting this out. And this issue with the subsidy provider wasn't her fault, in terms of their lack of payment. So we're trying to sort this out. She is working with the city of Detroit. She sent me email communications between her and her worker from the city of Detroit. Her husband is bedbound, and we were dealing with that. She was dealing with the issue of her husband coming sick. That mixed with the subsidy provider's lack of payments, she just needs 30 days to sort these things out. And I've made requests on the other side to discuss, negotiate the late fees, which are $150 a month. I haven't gotten any response, so we need some more time to negotiate and to look at these things.
All right, let's see if we can get it done by June 13th. You said your client is bedbound, or her husband's bedbound?
Her husband's bedbound, Your Honor.
So, Mr. Christensen, I'll allow for you to appear on behalf of Ms. Jones. I know we're going in person on the 13th. So if we can't get everything on the 13th. We'll deal with it on the 13th, but I'd rather not kick it out too far. And it looks like we have mutual consent for a 2-week adjournment. And that's around 2 weeks. So let's come back June 13th and hopefully we have some progress.
Excuse me. May I say something, please?
Sure.
If possible, can I get an updated ledger because the third party people that I'm working with, City of Detroit and DHS is asking for an updated ledger on
Ms.
how much I
Jones.
owe.
Yeah, I sent you one, Miss Jones. I'll send it again. I'll send one from today. But I just would like to put on for the record one more time, we are trying to figure out a negotiation or some kind of resolution regarding these late fees, but hopefully we'll be able to come up with something.
Okay. Time usually works some things out. So we'll be back June 13th.
All right. Thank you, everyone.
Thank you.
What time is that coming back around?
9:30. 9:30. All right.
Thank you.
Do you want me? Do you have anything ready with parties that are present? I know you would prefer to. 'Cause I don't think this is going. I'm thinking about sending the staff, everybody to lunch, and then coming back and completing this. But do you have any?
Your Honor, we have reached a resolution on case ending in 754.
Right, calling case number 754. Calling case number 2334-7254. This is Dolphin Garden LLC versus all occupants.
Good afternoon, Joe Horka, P75969, on behalf of the plaintiff.
Thank you.
Oh, I apologize, Your Honor. I think that's not the case.
All right.
I thought we were calling.
All right, let's see who's here. 7254.
It was 754.
All right, but while we're on this case, is anyone present from 12625 West Outer Drive? Unit 106. Right, council.
The case she's calling is 10 o'clock. The case she's asking about is at 10 o'clock.
Oh, okay.
It's Carmen McCoy and Bruce
Dinkins, 754.
Yes.
One second, council. Calling case number 2334-6754, Carmen McCoy versus Bruce Dinkins.
Good afternoon, Your Honor. Eleanor Karagian, P86696 with United Community Housing Coalition on behalf of defendant Bruce Dinkins. Mr. Dinkins, please state your name for the record.
Bruce Dinkins.
Thank you, Mr. Dinkins. And is Carmen McCoy present?
Yes, I am, Your Honor.
All right. Were parties able to work out some type of agreement?
Yes, Your Honor. We are going to be submitting probably later this afternoon a conditional dismissal with box 4A checked, giving Mr. Dinkins until July 9th to vacate the premises.
Right. Okay, this is a complaint to recover possession of property. So there is no amount to redeem. A conditional dismissal was entered by both parties, whereas defendant, Mr. Dinkins, agrees to vacate by July 9th, 2023, or a writ of eviction can issue a judgment, and a writ of eviction can issue after that date. It won't issue automatically, but this matter will be dismissed if parties vacate on or before July 9th, 2023. And Mr. Dinkins, Mr.
Yes.
Dinkins, do you give Ms. Karigian, your attorney, permission to sign your name?
Yes.
All right. Did I miss anything, Councilman?
I do not believe so. And I did send over the document to Ms. McCoy to sign and return to me as well.
Okay, great. Ms. McCoy, do you have any questions?
No, I do not, Your Honor.
Okay, well, thank you for your patience, everyone, and I'll see you all. Well, I may never have to see you all again, but good luck and have a great day.
Thank you very much. Have a nice day.
All right, you too.
Yeah.
Is Damone Huff here? Oh, Damone Huff
Yes.
is here.
Yes, Judge, yes.
I see. Is Tara Simmons here?
Yes.
All right. Are you represented by an attorney?
No, sir.
Have parties worked out any type of agreement?
We talked, we actually talked, we texted, but we haven't, we worked out a little something, but
I want to get it started now so we can see what's going on. We don't need some time, shit.
what was this?
All right, so.
What?
All right.
We did work out a little something, and I just wanted to let them know if is it gonna work.
You all want to go into a breakout room, but we'll likely call this case after lunch.
No, Judge, no, we don't need to go to a breakout room. The agreement wasn't fulfilled, and if you look in the exhibits.
Calling case number 23346763. This is Damone Huff versus Tara Simmons. The name Patricia Goldsby.
Oh shit.
Can you state your name for the record, Mr. Huff?
Yes, Damon Huff.
All right, Mr. Damon Huff. And Ms. Simmons, can you state your name?
Tara Simmons.
All right. All right, so this is a complaint for, let's see, non-payment of rent. What is the amount of rent that's owed right now?
Oh, I don't even have it up to date, but I did do a ledger, and the ledger is at 11,625.
Does that sound right, Miss Simmons?
Not to my knowledge.
When was the last time you made a rental payment?
Well, it was not a full rental payment. It was actually a little partial because we had agreed that he said that he just want the property back. So we had agreed. I said, okay, can I pay you a certain amount of money at a time until I find a place? And we did agree to that, but it was not written out.
So when's the last
And
time
it
you
was
made
for $700. Pardon me?
So you made $700 payment, you said?
It was for $700 in which I was paying this week.
So you haven't made that 700 yet, correct?
No, not yet, Your Honor.
And when's the last time you've made a rental payment?
It was March. What's this? May, like March.
No, it was January.
Okay,
in the ledger.
January.
Yeah, it was January. I have received partial payments, never a full amount. It's been going over a year and a half. So she has always, did something contributing to it, but that total amount is from, the lease was a year. So we're over a year and a half, and that's why I want the property back, because, I had to bite that bullet.
Okay, how much time do you want to give her? How much time do you need, Ms. Simmons?
30 days.
This is a non-payment of rent case. So we'll keep it at a non-payment of rent. There's also a money judgment on this matter. It's personal service for money judgment. So are parties in agreement with 30 days to pay 11,625 or vacate?
I mean, we're in agreement. I'm in agreement with that.
Yes.
All right, court's gonna enter a judgment for $11,625. This is a money judgment. Plaintiff paid for it and received perfected service. It's a money judgment where you, Ms. Simmons, agreed to either pay $11,625 or vacate by June 26th would be the date, the first business day. June 26, 2023, or a writ of eviction can issue after that date.
I understand.
Ms. Simmons, you
Yes.
are unrepresented by an attorney. So that means Michigan Court Rule 4.201 subsection I. 4.201 I, it's a right. You have a right to file an appeal or a motion in the event that you come home and say, oh, I shouldn't have made this agreement. Because you're not represented and you're agreeing to this, you have the opportunity to file a motion. It has to have some merit to it, but if you file it, we'll hear it, and that's if you need to do it. That's just a right that you have, and I have to let you know that that exists. We're not in person, so you don't want to pay them.
Thank you.
Okay, so pay or vacate, pay $11,625, vacate by June 26th. But good luck. Thank you, Mr. Huff. Thank you, Mr. Simmons.
Thank you, Judge. You too.
Thank you. Thank you, Mr. Huff.
No problem. You too. Thank you.
Attorney Luan, I think this is the last one.
Yes, Your Honor. We spoke with Mr. Samuels, and if you want to call the case, we would like to ask for an adjournment.
Okay. All right, calling case number 233467776, 6777, 6778, and 6779. This is Dorothy Williamson versus Curtis Samuels.
Good afternoon, Your Honor. Suzanne Stepich-Lawan, P48702, Michigan Legal Services, on behalf of the defendant, Curtis Samuels. And Mr. Samuels is in the courtroom with us. Mr. Samuels, will you unmute and state your name for the record, please?
Curtis Samuels.
Thank you.
Thank you. And Ms. Williamson, can you state your name for the record?
Miss Dorothy Williamson.
Thank you, Ms. Williamson. All right. This is a case, Mr. Samuels has four separate cases. Mr. Samuels, are you currently occupying 4 different units?
Just one.
And what unit is that?
Apartment A?
Apartment A?
Yes, sir.
Is it 1A or 2A?
It's 1A.
Okay, so is it my understanding that 2B do you have any items in 2A, 2B, or 1B?
No.
All right.
Your Honor, if I might, this was brought as a health hazard case, I believe is how it was. And we are not sure who the owner is. We've not seen the court record. If we would just need some time to review the court record and make sure that the pleadings are in order, because with the health hazard case, there are certain statutory requirements for notice and ability
Okay,
to.
at some point, like, how are we supposed to get this to you?
We have someone at the court every day. If you can set it aside, I can make sure somebody comes by tomorrow.
I was actually going to say Patrick might still be there today. Sorry to cut
He
in.
might.
See if he, we may be able to have somebody stop by in a couple minutes if he's still there.
Thank you.
Okay, now, Mr. Samuels,
Yes, sir.
do you have items in any other of these units?
Yeah, downstairs. I have a whole lot of stuff there. I'm a mechanic. I have stuff all over that building.
You have
It's a
stuff in
two-separate building, but they
Do you have
joined
stuff in
together.
Do you have stuff in unit 2A?
No.
Are you, okay, so in unit 2A, do you have any interest? I mean, I could dismiss this case, Ms. Williamson, and you're entitled to access to the property. Mr. Samuels is saying he's not occupying that property. So
Your
why
Honor,
is there?
Mr. Samuels also has a question as to the ownership of the building. He believes the landlord is someone other than the plaintiff.
Oh my goodness, this is, all right, but he doesn't have anything in the property that he doesn't own or she doesn't own. So we could dismiss this case and we can have one out of the 4 done, and I can give you an adjournment, someone can look at these other 3 files. But why is it even relevant that, because I'm going to dismiss this case?
Okay. Your Honor, this is Mrs. Williamson. I have a deed on file. I went down to the 36th District Court as Your Honor before, the case that I was presented with before. I'm not familiar with the judge's name, but she had me to go down to the 36th District and put a recorded deed on file. So the deed under my ownership, it is recorded on file. And as far as those 4 units, Your Honor, he does have items in all of those units. He does.
No,
he does have. I'm not gonna be Mr. Dishonest, Mr.
One of the two.
Mr. Curtis.
All right.
Your Honor, there's a deed on file. So I did go down to record the deed that we have ownership of this property.
Okay.
Your Honor, we just need to investigate a little bit. If we could have a couple of weeks, that would be great.
I can't give you a couple of weeks because you're creating arguments that you aren't sure are even existing in a sense, but you also haven't seen the file, so.
And Your Honor, it's a health hazard case, so we may very well be looking at a trial to present evidence to the court.
Okay, my point was just that if you don't have items in one unit, then she can get possession of the units you don't have items in. But either Ms. Williamson said that there are items in all units, so.
There's items in all units. There's no running water there. There's electricity. We have had to have DTE to come and cut the there's lights that are being extracted to give him power to the upstairs. Now, under this ownership, that's damaging to what I have there. You know, there's still a cord he has running from the upstairs to the downstairs right now. What he's doing is hazardous. And at this moment, I did what the previous judge asked, Your Honor. She asked me to bring record that my name is on that building. You have that.
All right. I hate to delay this because I have to locate it.
That's fine.
But see, shit, I'll put it over another week. We'll keep this digital. And
I have a question, Your Honor. This is Ms. Williamson. I have a question. Is he still living in the building, occupying the building that is deemed hazardous with no running water. Electricity, DTE has come out numerous of times and cut, matter of fact, twice. I'm not going to be dishonest with what I'm saying. We had to have them out twice. So is he still living in the building, or does he has his things there, you know, holding me up from going in there and doing what me and you know, partners that I have partnered with to get this as a up running business? I mean, is he liable to live in a property like this? You know, with the lights, I don't know. Are they on right now, Mr.? You know, I don't know. DTE cut them off. I mean, come on, is he allowed to do this?
Ms. Milan, do you know if your client is paying for electricity?
I do know that we didn't get that far, Your Honor, thinking we could get this adjourned and figure it all out since there's so many different issues. I did just hear from Patrick Carey, who's down at 36th District, and he will come by your courtroom to pick up the file.
Is there any way, Your Honor, that she could find this out today? I'm a mail lady. I work for the city of Grosse Pointe, and I have to take time off of my job to come here. And I did it the last.
Patrick, let's have Patrick do what he has to do, and then we still have some more cases left, and if we can get this resolved today after you view the file, then that'll work. And let's just try to get it done today. And if not, then we'll have to figure it out, but we still have some time. It's still the morning, it's still early afternoon, and we're gonna take a break right now. It's 12:30. We'll be back at 1:30. We'll leave the courtroom open. Those four, I'll leave them up here for Patrick, and then we'll come back after lunch. And if we don't have a resolution, then we'll come up with one.
So Your Honor, Patrick just asked when you're doing lunch so he can swing by before you leave and not interrupt court. Should he just come now?
Come now. Yep. You should come now.
And should Mr. Samuels, do you need him back at 1:30 as well?
I don't know. I would like to know whatever information that I ask, it'll be good to know. Yes, I need him back at 1:30.
Okay.
All right.
One last question, Your Honor. It's Ms. Williamson. So since he's not inhabiting the other 3 units, so I have full access to my other 3 units? Because I wouldn't go in there and do anything because there are, you know, things in there. So I mean, are those other 3 units free for me to access at this moment? And have, you know, where I can take all of those things out of there and have them thrown out? Once again, I mean, the deed is there with you. I put the deed on record, so.
Your Honor, if this could wait till this afternoon, I will talk to Mr. Samuels during the break and we will figure this out.
Okay, all right. I'll see you all back at 1:30.
Okay, thank you.
Thank you.
Your Honor, before we leave, could I just have a breakout room with Attorney Horka, please?
I'm just gonna give you I'm gonna give you a privilege so you.
Thank you.
They ain't gonna do nothing unless you in court.
Oh, I'm sorry, Your Honor, did you say it was okay for Patrick to stop by to get those files?
Yes.
Okay.
I already let him know, Hillary.
Oh, thanks.
Thanks.
This is what I'm trying to tell you, not listening to me. See, she won't. Already, I can see it already. I gotta get a place to put that shit.
Mr. Samuels, I'm gonna pull you into a breakout room in just a moment and we'll talk, okay? Mr. Samuels, we just sent you an invitation to go to breakout room 6. If you could join that, you and I can talk.
And is anybody still in the courtroom, Your Honor?
He said Curtis could stop by and pick up the file.
He did, but Patrick just sent me a message that nobody's in there.
Can he get in there at all? Because maybe he just
Here.
left his desk. Oh, the joys.
Yes, he can hear us talking. So I guess he must be in there, but nobody else is at the moment. So
Okay.
We'll figure it out. Also, we're still on YouTube. So
Okay. Well, maybe he just set it on the side of the desk if Patrick can hear us.
fair enough. How about you go talk to Mr. Samuels and I'll see what we can figure out with Patrick.
Thank you.
Hello?
We can hear you. The court is on recess until, I think, 1:30. So please stay muted.
Okay.
Attorney Fisher, are you available for a breakout room?
Yes, I am.
Okay, I'll meet you in room 7.
Okay.
Hello,
Good morning. What's your name for court? I mean, good afternoon. What's your name for court?
Mindy Nicole Page.
Mindy?
Hello, Nicole Page.
You might be in the wrong courtroom. Were you here this morning? What case are you on?
They got me ticket, SP 1441891.
Yeah, you in the wrong courtroom. That's a traffic matter. This landlord tenant.
This was this lady gave me. when I called 36 District Court.
Yeah, you got a traffic matter?
Yep.
Yep, this landlord tenant, Judge Adam Sabree.
So I got to call back.
You got a case number? Once the clerk come back, maybe she can look it up for you.
Yeah, I got 2 tickets they gave me.
Okay.
Yeah. Cause I had just got off the phone with her and she gave me that number to go on Zoom. You ready for the number?
Give me a second, or you might have to, well, Your Honor.
So I got Jamie
Good
McCray.
afternoon. Is the clerk back? She have traffic matters, or should she call back to the court and try to figure out where she need to be?
Okay, so you got traffic matters?
Yeah, Judge McCree, Jamie McCree, I think.
Judge McCree.
Jaymy, McCree.
Is he a visiting judge right now?
Huh?
I don't know who Judge McCree is.
Oh no, I think that's the officer name. Oh, Garrett R. Garrett R.
Oh, Ruth Garrett. What one is that? That's 4-5, I think. Isn't that next door? 435? No, I'm not sure. Let me see.
Or I can give it to you.
Okay, Ruth Ann Garrett is in 437, so it's 360-437-0000. Or is it? I thought that was on the directory.
Let me see. Unless she came in here, last week?
Is it, you said A. Garrett?
It said Ruth Garrett, R. Garrett.
Oh, Garrett. I thought she said.
I think she next door.
Yeah, 437. Tell her she's gonna be tomorrow. I don't know why I thought she said Carter. Because her name is Carter.
Yeah, that's why. Yeah. There's a lot of people coming in. They're here from the morning doc.
No wonder why you was like. So.
Is Tommy Roan here? Calling case number 2334-6453. This is Tommy Roan versus Jane L. Transmission. Nobody has responded. This is the third time I've called this case. There's no attorney for the defendant. This matter is dismissed without prejudice. Parties can refile upon motion or refile a new case. Well, parties can motion to set this dismissal aside. Are parties ready on Catherine Baker?
Your Honor, I still have not had final word from Attorney Horka.
Okay. All right, is Sheridan, okay. Is Counsel Montgomery here? Okay, is Donna Higgs here? Is Unique Owensby here? Is Mario Brown here? Calling case number 2334-6761, Mario Brown versus Mana Nibla. Mario Brown. All right. And that is case number 2334-6761 Mario Brown versus Anna Nieblock. And parties on Kentucky, 20444 Kentucky. Defendant, well, plaintiff has failed to appear as well as defendant. This matter is dismissed without prejudice. Parties can refile. Is Clarissa Valentine here? Clarissa Valentine. Is Andre McCullough here? Is Bridget McCullough here? Our parties here on West Outer Drive. Does anyone live at 12625 West Outer Drive? Our party's ready on Transasha, Washington.
Judge, this is Attorney Johnson. I'm waiting on to speak to Mr. Horka. I don't see him in the courtroom again.
Okay.
Washington.
All right, thank you.
Okay, Jamal.
Is Sheila Phillips here? Sheila Phillips. All right, and is Kyra Morgan here? Kyra Morgan. Ms. Robinson? Keyway Robinson?
Oh, hello.
Yes. Can you say
I'm here?
Who are you?
Zikwe Robinson.
Okay, is Kyra Morgan here?
She was here earlier.
Did you all work out an agreement?
Yes.
Calling case number 2334-6701. Kyra Morgan versus Ezekiel Robinson. Can you please state your name again for the record?
Zikwe Robinson.
Thank you, Mr. Robinson. Is Kyra Morgan here? Let's see if anybody's trying. Yes. All right, Kyra Morgan. All right, Mr. Robinson, what was the agreement?
She said she was going to give me 2 weeks to get everything situated, but I heard that there was a possibility that I can get 30 days, so I want the 30 days. If possible, Your Honor, I'm sorry.
I'm going to do a judgment by hearing. You want 30 days?
Yes.
All right, do a judgment by hearing where all right, well, this is what I'm gonna do. I'm gonna adjourn your matter. Gonna have you come back to court one more time. Ms. Morgan was here. I will give you 30 days, but I really don't want to put a judgment in your name, Mr. Robinson. And I could dismiss this matter, but out of fairness, she was here earlier, so I don't want to dismiss it now. So what I'll do, I'll adjourn this matter for 2 weeks, and then that should get you in the. So in 2 weeks, that would be your 14 days, and then you get 10 days from there. That's almost a month anyway. So if I enter a judgment today and give you 30 days, but if you just here, then I will have to put this judgment in your name because there's nobody to agree to removing your name. It's all actions. So I'm going to adjourn this case to June 25th, June 13th, Tuesday, June 13th. Okay.
Yes, and I have to come in then, right?
Yeah, you will have to come in on the 13th. Let me check the, well, it's the morning, so you'll be all right when it comes to parking. So let's do it at 9. I'll set it for 9:15. That'll be enough time. She'll get re-noticed. You talk to her, let her know it was adjourned because I didn't want to put a judgment. Well, she left, so June 13th is your new date.
Thank you.
Well,
I can get off of this thing now?
yes, you may. You have a great day.
You too.
All right, is Attorney Doyle here?
Good afternoon, Your Honor.
Good afternoon. Okay, I see you, Attorney Doyle. And 876, who is? Do you know who the defendant is, Mr. Attorney Doyle?
No, Your Honor, this was any and all occupants of 20170 Cary Street.
27, could you give me the address one more time?
Yes, it's 20170 Cary.
20170 Cary?
That's correct.
How you spell it? Kerry?
Carrie.
Oh, okay, okay. That sounds more familiar. Okay, I call defaults an hour after, so we still have 40 minutes, but does anyone reside at 20170 Cary? You're the only case in the afternoon. Does anyone reside on Cary Street? No. And Ms. Hurston, what case are you on? I'll recall your case, Attorney Doyle. And pop your hand up at 2:30. Pop a digital hand up, and I'll make sure I get you out of here. And Ms. Hurston, what case are you on?
I'm on Virginia Park. Let me see, Money. I can't pronounce her last name. Cocancoughger.
Coconauer?
Yeah.
I'm here. Coconauer, okay.
And,
all did. Fisher?
Yes,
Yeah.
yes, this is Attorney Fisher. I need to get in a breakout room with my client,
Okay.
Kokanagar.
Where is she?
She is the
I'm here.
248. Oh, yeah, she's the 248-379 number.
Okay, I see it. All right. Let's see.
Room 2, Ms. Fisher. There we go.
All right. And our parties, Attorney Lewan, did you have an opportunity to review the file?
I did, Your Honor. I am trying to get my client back into the courtroom.
Okay. Ready?
So you might want to give me a minute. He doesn't seem to be responding to me. Can you just move him in here as host?
Oh, just invite. All right, we'll give it a second. He may have stepped away from his device or something.
Okay, I'll duck back in there and tell him he has to accept the invitation. I'll be back.
Okay. All right. Mr. Harker, are you ready for me? Miss with their hand up. You're muted. Please don't get in an accident.
Oh, I'm sorry.
Hello?
Hello? Good afternoon.
I'm trying to figure out, excuse me, can you hear me?
Oh, because you're driving. You're driving. I can't hear you. Your signal's going to continue to go in and out, and it's dangerous. Just when you pull over, pop your hand back up.
Okay.
All right. All right. All right. Okay. All right. What can you? It sounds like, looks like you have a signal. What's going on?
just want to know if they called the case for 643 University. 64321 University. Did you call that case?
I don't have it categorized by addresses. Do you have a case number?
I gotta give it to you. I'll give it to you in 1 second. I gotta look it up.
Just send it to the chat. All right.
Okay.
All right.
Citizens may now pay
Hey.
tickets, schedule a hearing, view case and calendar information.
All right, is Donna Higgs here? Donna Higgs. Calling case number 23346728. This is Dynamo RE LLC versus Donna R. Higgs and occupants at 18473 Rosemont.
Yes, good afternoon, Your Honor. William Simon on behalf of the plaintiff, 80352.
Donna Higgs here. This case was scheduled for 8:30 a.m. It is now 1:57. This is a complaint for non-payment of rent. Counsel, how would you like to proceed?
Yes, Your Honor. At this time, we'd like to ask court to enter a default judgment. The defendant is owing at this time, let's see, $7,250 in past due rent, plus $160 in court costs for a total of $7,410. Yep, we ask court to enter a default judgment.
All right. Default judgment is entered. Defendant must pay $7,410 by June 5th, 2023, or a writ of eviction may issue.
Thank you, Judge. Thanks for reminding me. This one looks like we missed this one this morning. But thanks again.
Yeah, sometimes. You're welcome.
All right.
Have a great day.
You as well.
All right, I'm ready for you. iPhone.
Hello?
Hello. All right, were you able to track down that case number?
I'm trying to get it out of my email. It was on a case with Gary Sagatti. He was the attorney on it. Because I was on this morning and they was on, but I didn't understand. Hold on.
That's just when you get the case number.
Okay. Okay, hold on.
Hello, have you called the case of 233-447-176?
Said 176.
Yes.
Actually, I did call that case. You said 233-47176.
Yes, sir.
Was Attorney Devlin?
No, I'm the tenant.
No, but it was with Attorney Devlin, correct?
Oh, I don't know.
Do you have any paperwork?
Paperwork? No. Only from the first time I got my eviction notice.
Yeah, we heard that matter. That was scheduled for 8:30 this morning.
My notes say 10 this morning. I was told 10 a.m. And I've been on this phone since then.
And Your Honor, this is Attorney Burley. She also called into Judge Kennedy's courtroom first, and I think had some trouble getting over here.
Yeah.
How did you have, I mean, what trouble did you have getting over here until?
Yeah,
like,
because I didn't remember to call your number to put the ID number in.
Yeah, I don't know what time we called your case. Technically, it's not. Not on my docket, really. They didn't really transfer it over to my courtroom, so technically it's still in Judge Kennedy's court. I just processed it because I want to continue on. And schedule, it shows that it's scheduled for today, but we're trying to figure out what was going on with this case, but yes, we have defendant here now. What's your name, ma'am?
Kylie Ragland.
Right. All right, I have to wait until my clerk gets back to see what the resolution was. And then I have to file a motion to reinstate. Call Attorney Devlin. That's him. Otherwise, I'll rehear it.
Excuse me, did you call 2737? Name Lakeisha Dawson.
Two 737.
Yes.
I don't have a 27.
No, it's 7237. My bad.
You said 277. What'd you say? 97?
It's 2737. No, 7237. My bad. Hey.
7237. I don't have. And do you have any paperwork?
Yes. My appointment was today at 1:30. But I just got another one in the mail like a couple of days ago saying Thursday, June the 1st at 1:30. But when I went last time, they told me today was supposed to come in. And I got the meeting ID number.
Okay, and who's your judge?
It was her name was I don't even really know her name.
Judge Kennedy.
Huh? Yeah. It was her it was like 2 weeks ago, 2 or 3 weeks ago, and they adjourned it till today and gave me this meeting ID number for 1:30. But I got another letter in the mail saying Thursday, June the 1st at 1:30.
All right, so your case number,
Was that just,
hold on one second.
was that just a Kennedy?
And what's your case number?
My case number is 233-47237.
I'll try to track it down.
Okay.
Ms. Ragland,
Yes,
is your case number 233467776?
no,
It's 7176?
yes.
For June 1st at 10.
Scheduled for June 1st at 10 o'clock. Yeah.
For north of Portugal
That's
versus.
for Ragland?
Yeah, for 3065 Parker.
No. 3053 Seaburn.
Give me a good case number.
Because 233471776 is all occupants at 3065 Parker Street.
No. 233-47176.
Wait a minute. You said it one more time. 233-174.
No, she said 233471776.
7176.
So hang up the phone.
Yeah, until it.
Hang up
Yeah,
the
I don't-
phone.
Me?
No,
Who
no,
had
ma'am.
Miss Fisher's.
Yeah, that's what I have. We're pulling up 7176, and this is north of Kirchhoff versus someone on what street is that? On Park. All occupants on Parker. 3065 Parker Street.
Yeah, I'm not on Parker Street.
Okay, I need another case.
She the defendant.
What's your name, ma'am?
Kylie.
Yeah, Kylie Ragland. Kylie.
Keiley.
Keiley. Ragland. Ragland.
Yes.
And Your Honor, it looks like she spoke with Kiana Bonds from our office. But we've got the, what is it, Seaburn address as her address, but I also don't have her like ID or anything.
Let's say have this in the system wrong. It's not coming.
Don't make no sense.
2007. Closed. Definitely not on the street.
Yeah.
It's in the city. This is on.
Yeah.
Have her fall downstairs to the second floor. Have her fall downstairs.
Oh, you should call down on 2. They can locate your case.
She can call 965.
965 313-965
3834.
3834.
Tell them to give me about 5 minutes.
And give it about 5 minutes. Because the person who said call, she's in this courtroom. She'll try to locate it on 2 for you. Give it about 5 minutes and then give that number a call. And then I have one more. All right, and case number ending 2334-7237. NBA management versus occupants on Belgium Street.
Yes, I'm right here.
Yeah, but yeah. But it's scheduled for June 1st.
Okay. And then what was that dismissal?
Dismissal, it's not entered, but it's been submitted on May 10th.
Okay, it was a dismissal that was submitted May 23rd. You're scheduled for a court date on June 1st. This is the case number ending in 737.
You say ending in what?
You're scheduled for June 1st, but a dismissal was filed. It just has to be signed. So without prejudice that was filed, so your matter is dismissed. It's just the court has to sign it. It's in the stack of files to sign. So
I come back June 1st.
You can zoom in June 1st at 1:30 just to make sure your case is dismissed.
Okay.
But it's in the computer. It looks like dismissal was submitted, but it hasn't been signed yet. I haven't signed it yet. When I get to it, I'll sign it. But it looks like your matter is dismissed. So just to ensure we'll check in June, but I don't see the landlord doing anything other than that because he already entered the dismissal. So probably.
Okay, thank you.
You're welcome.
Bye-bye.
Bye-bye. Attorney Fisher.
Yes, Your Honor. This is Amani Kokonaga. The last 3 numbers are 550.
Calling case number 233455550. This is Virginia Park Townhomes versus Amari Kokonaga.
Good afternoon, Your Honor. Joe Horka, P75969 to be at the plaintiff.
Good afternoon, Your Honor. Janetta Fisher representing Imani Kokonaga. I'm with Michigan Legal Services, P72872. Ms. Kokonaga, please state your name for the record.
Imani Kokonaga.
Thank you, Ms. Kokonaga. Are
Mm-hmm.
you able to work out some resolution?
This is a non-payment of rent case. My client is also present in the gallery if testimony is needed, but the current balance is $7,422. The defendant is disputing the rental rate, but my client can testify as to the notification and the reason for that rental rate. We have not been able to agree with the pay or move out date as well.
And Your Honor, that is correct. My client does dispute the payment. She did receive an offer. She did receive an offer of a consent judgment from the plaintiff to convert this from non-payment to termination with a vacate date, 30-day vacate date, and also for both parties to preserve their right to file future claims. But my client, she just cannot understand why she needs to move.
Okay. So what do you say the amount is, Ms. Coconut?
I don't owe because I don't have anything in writing from them stating that I owe this money. I didn't know anything about this money. Lisa Bond was supposed to remove this out of my file last year. She did not. She told me that she would come from Lansing and handle this because the girl that put it in my file had quit. Now, I do not appreciate it because I have every bank statement showing that I've been paying my rent since 2008 with no problem. Every single month I have paid. Now, all of a sudden, you hire this girl, she put this in my file, and then she quit. Now, I go over their head, and now it's a problem. It should not be a problem here because I pay my rent every month. Where did this $875 come from? I don't know. I never seen nothing in writing. I wasn't given nothing in writing, so I continue to pay my rent.
All right. You have anything else? Ms. Coconut, you say you have receipts. Can you get those receipts over to the other side and then they can verify them and then we wouldn't have a balance, correct?
I have all my receipts. I gave them to Ms. Fisher.
And Your Honor, I did go over
got all my bank statements.
Your Honor, I did go over the receipts she sent me and I reconciled them with the ledger. And her payments are on the ledger.
Okay. So, Ms. Coconut, based on the receipts you provided, there's still an amount of $74.22 that's owed.
How is that? How is that if I don't have nothing in writing? Nobody told me this. Nobody told me this at all.
All right, I'm going to start muting you if you don't stop. When is the last time you made a payment, made a rental payment?
The last time was in January, and that's because Ms. Hurston sent me a note stating that she was going to take me to court for squatter's eviction and she will no longer accept my payments. The same day that I paid my rent is the same day I got this note. So I did not pay. I do have a, go ahead.
You just told the court that you pay your rent, and now you just told them that you haven't paid since January. So
who am I going to pay it to if she's not accepting it?
I'm pretty sure that someone will accept it because they have to accept it. You're getting sued for a non-payment of rent.
Oh, you know what? Wait. Let me calm down. Okay. This is what happened. When all of this 875 came up, they sent me a letter.
875.
I don't know. Something that they sent me saying that I owed $875 for rent. It was $2,195. I called them immediately. I say, what is this about? My neighbor called. She said, did you get a letter? I said, yes, I did. They saying I owe $2,000. She said, they say I owe $200. I called Lansing. That's Lisa Bond. I called her. I say, Lisa, I don't understand where this coming from. She said, well, Imani, don't worry about it because LaShonda messed up a lot of files, and I'm going to have to come down to Detroit, and I'll pull your file to see what's going on. I say, please do, because I don't owe anything. She said, I see where you've been paying every month, but she had messed up a lot of files, and she's no longer here. I say, so how is that? What does that have to do with me? I didn't even know the girl even quit. I say, so you guys let her put this in everybody's file and nobody was informed about nothing. It's saying that I owe $2,195. I say, I don't owe anything. She said, you're right, you don't owe, but we have to straighten out a lot of files because of the audit. I say, okay. She came down here. She never She never got to me. I called her back. She said, I'll get to you. I have to come back down to Detroit next week. If you don't hear from me by Tuesday, I will try to get back with you Thursday. I said, okay. She never did. So I was calling Lisa back to back, back to back. I stopped even calling Virginia Park because Lisa is the main person that handles Lansing. So
Okay.
she never.
Hold on. Let me stop you.
Mm-hmm.
You talking now?
Yes.
Did you make a January payment?
Yes, I did. For $904. They even told me that I had to pay $904. I said I thought it was $875.
No,
it's
no, it's not. Well, I need you to stop. All right. So it's clear that February, March, April, and May are owed, right? And hit *6 on your phone. Unmute. I shouldn't have unmuted.
okay. I'm sorry. Yes, February, March, and April, I did not pay because January she sent me a note stating she was not going to accept it because she's taking me to court for squatters eviction.
Okay, so what about May? Did you pay May?
I did not pay. I did not pay for those months. I don't even know what I'm supposed to pay. Is it $550, $875, $904? I don't know. The only thing I go by is my lease. My lease told me $550, and that's what I've been paying. But now it's $904. And they have no proof. I don't get this.
Leaving out quite a few details here. One, she had relinquished possession of the property and moved into another unit under a subsidy. Then she moves back into the unit. She doesn't recertify her subsidy here, so she's been adjusted to market rate. She's been hounded by my client, who's present in the gallery, who can testify about her efforts to get her to turn in the required paperwork so she can remain on an income-based subsidy. She refuses to do so. She's on market rate. She can't afford the payment. We've tried to negotiate a reasonable resolution here, and she won't work with us. So I'm asking for a judgment.
No, that's not true. But go ahead. That's not true.
All right, and can you let your who's your property manager or
Virginia Park?
Ms. Hurston.
Yes.
Hurston, do you swear to tell the truth and nothing but the truth?
Yes, I do.
All right. Mr. Horka, would you like to voir dire her?
Sure. Ms. Hurston, what is your title at Virginia Park?
Property manager.
Okay. How long have you been in that position?
Since October 17 of 2022.
And are you familiar with the named defendant here in court?
Yes.
Okay. And do you have access to a ledger that you would have knowledge of her balance today?
I don't have access to it. I don't have access to that ledger, but I did upload a ledger to your system yesterday because I'm not actually in the office, so I can't take files out of the office, but I do have the ledger balance. And the whole situation in this case came about with the resident moving out of the unit. She had told us that she was moving on. She had all of her things in.
Hold on. I'm gonna mute her. Don't worry about it.
Okay, she had all of her things in the move out truck, etc. She had actually signed a lease and accepted keys at another community with a separate voucher of her own through Section 8. The balances that are occurring from there is from January or February on, including any all damages to the unit. But she held both places hostage with keys. She wouldn't give us ours back, and she wouldn't give the new place back because she didn't want to move in it. They ended up forcing her to mail the keys back through her other agency. I've expressed to her, if you bring me your information, you and your son's income, I can then adjust your rent to what you should pay. She will not do that. I have forwarded those documents to the lawyer to pass on to her to have them filled out. She will not do that. So she will be at 904, which you now know she knew it was 904 until then.
Thank you. All right, so there's a consent judgment with a 30-day vacate date that was offered. Ms. Kokenauer, are you interested in that offer? You please press *6 to unmute.
I'm sorry. Okay. I was saying I need to address what I need to address because she just stated she just got here in October. This happened last year. She was not on the scene when this took place about this money. Now, if she's talking about that place that I'm supposedly moved to, we stayed there 1 hour and a half. Oh, this is not going to work for me. This is not going to work. I am very heated.
Your Honor, could you give her at least 45? Your Honor, could you give her at least 45 days? And the reason why I asked for that, she is disabled, and she also has a 19-year-old son who is disabled also.
She's disabled physically?
Mentally.
Yeah, she
Miss
just said it.
Hurston, please don't say nothing. Please, at this time, please don't.
So could she have at least 45 days?
No more.
Yeah, my client was
telling you.
She asked for 10 days today. In good faith negotiations, got up to 30 with Ms. Fisher. Again, there's been a lack of communication, a lack of compliance with this unit. She's had issues with other units too in the process.
Don't even say.
I'm asking for 30 days.
Please let me talk.
I'm gonna let you say one more thing. I'm gonna let you say one more thing, Ms. Coker. Go ahead.
Look, this is not fair to me, okay? They are badgering me, for one, because they have violated me and my son for the last few years. Ms. Hurston was not here when none of this was taking place, when I've been trying to fight and fight and fight. I have proof on every single thing I'm talking about. The reason why they want this unit is because of the stuff that they have in here. And the lieutenant told me, do not let this happen. If you can fight it, fight it. And I am going to fight it. For one, my mother passed away. And this is when they started this harassment and retaliation against me, because I went over their head and I called HUD and told them about the things that they have been doing in here. And they've been putting everything on me ever since. They have stolen from my bank accounts. I have proof from that. This is what they want me to pay back. I'm not doing that, Judge. I'm not, because I am not sitting here making this up about these people. Me and my son have been through hell staying here. If you come and see what we're living in, we got carbon monoxide we've been breathing in here. Do you think I am about to sit here and let them just destroy us? I'm not going to do this. Ms. Hurston don't have anything to do with this fight. This is Lisa Bond, and I'm trying to explain to you the best I can. We've been in hell. I had to buy my own stove. They did us. They violated my rights. Do you hear me?
I hear you, Ms. Coker.
My mother passed away when I typed in them bank statements. We've been going downhill. I know what this is about.
Ms. Coker.
Yes, please hear me.
I heard everything you said, and I've allowed you more time to speak than anybody else in this entire document. So I appreciate what you're telling the court. And because of that, I'm going to enter a judgment, a judgment Is there any objection to a comment? I'm gonna enter a judgment for, today's the 22nd, I mean 25th.
Oh, Judge, I wish I could talk to you.
June
I wish
23rd.
I could.
June 23rd, 2023. That is the date where the court's requiring you to either pay or vacate. Ms. Coconauer. That'll give you until June 26th. A writ cannot be filed until June 26, 2023.
And Your Honor, what is the amount that you are saying for pay?
Don't even owe nothing.
I know 4520 is a legitimate number, and
for who? For
20 plus costs and I guess late fees.
Yes.
You know, I have a detailed
No.
one, 7,422.
And if all the payments are credited as stated, Ms. Fisher, I don't have any reason to lower this amount.
Okay, so we're saying, what we're saying, it will be the amount that is on the ledger. Is that correct? So we're talking about, so it's either pay or vacate.
I'm not paying anything, Helena. I'm not. I will take you to Washington.
And the amount on the ledger.
I'm going to take her to Washington.
And the amount on the ledger is $7,422.11. Is that what we're saying, Your Honor?
Yes. $7,422 must be paid by June 30th, or a written issue.
June 30th.
So it's June 30th?
June 30th for a written issue. Good luck, Ms. Coconauer.
Okay, now what are you saying to me? What are you saying that I have to do, Judge?
Saying that you have to pay $7,422 by June 30th, 2023, or vacate by June 30th, 2023, or writ of eviction may issue as early as July 3rd.
Okay, I don't have no 7,000 nothing. So what I don't have any money to pay. They took what I had. I don't have any. So what do I do?
Try to
Your
find
Honor,
some.
Your Honor, one other question I would like to ask. Can this be put in the name of all occupants?
Any objection? Mr. Horton?
That's fine, yeah.
Thank you.
I don't get this. So I have to pay?
JBH.
Amani.
So judgment by hearing. Yep, judgment by hearing, and it's an all occupants judgment. That puts you in a better position, Ms. Coconauer. The judgment won't be in your hand.
Okay, Amari, I'll put you in the breakout room so I can explain this to you again, okay?
Okay.
All right. Good luck, Ms. Coconauer.
All right.
Have a great day.
You too.
Thank you.
Okay, now, what is, because I'm.
All right, what else you got, Mr. Horton? Let's see.
I think I have a handful, maybe a few less than that. I think I have like 3 to 5 potential defaults.
I think so too. Is Council Montgomery up? Is Counsel Montgomery here?
Okay, she's taking me to this. Oh God, this, oh no.
Counsel Montgomery, calling case number 2334-6713, Sheridan Court versus Counsel Montgomery and all occupants. That's your case, Mr. Horka.
Sorry, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Is Counsel Montgomery or anybody on 4417 Second Avenue present? All right, Counsel, this is a complaint for non-payment of rent. How would you like to proceed?
Based on the defendant's failure to appear, I would request a default judgment.
Default judgment is granted.
I'm looking at this case now here on executive dismissal.
Okay, all right, that's fine too. This case is dismissed without prejudice. That's 713. All right, is Unique Owens be here? Calling case number 2334-6757, Rondo Investment versus Unique Owens.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Is Unique Owens be here? Anybody on Algonac Street present in the courtroom? All right.
This court to enter a default judgment. Current balance is $1,970.
$1,970.
Yes.
Okay, and that $1,970 must be paid by June 5th, 2023, or writ can issue. You must pay or vacate by that date. 757. On case is Christopher Donahue here. On case number 2334-6771, Sheridan Court versus Christopher Donahue.
Good afternoon, Joe Horka, P75969 appearing for the plaintiff.
All right, does anyone live on 2nd Street, apartment 106? All right, counsel.
Also moving to dismiss this matter.
Not an issue. Dismiss without prejudice. 771. Dismissal. All right, calling case number 2334-7211. This is TGRF Owner LLC versus Clarissa Valentine and all.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
All right, thank you. Is Clarissa Valentine here? No, Miss Valentine. Does anyone live on Riverfront Drive, apartment 2503? Defendant failed to appear. Counsel, are you requesting a default judgment?
Yes, Your Honor. Total amount due is $1,472.80, please.
Could you get that to me one more time?
Sure. $1,472.80.
Okay, thank you. And that must be paid by June 5th, or a writ may issue. Calling case number 2334-7250, Logical PM versus Andre and Bridget McCullough.
Good Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Is Andrea Bridget McCullough here? Here to be present. Let's see. Counsel, are you requesting a default judgment on this one?
Yes, Your Honor, including court costs, looking at a balance of $1,724.12.
1724.12.
Yes.
A money judgment was pled for, but I don't see personal service on this file. Just stating that for the record.
I agree.
But default judgment is granted. Defendant failed to appear. Defendant must pay $1,724.12 or vacate by June 5th. Or writ may issue. Calling case number 233-47254 Dolphin Garden LLC versus all occupants at the address of 12625 West Outer Drive, Unit 106.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Thank you. Anybody? Unit 106 on West Outer Drive. All right, counsel.
You know, I'd ask for the court to enter default judgment. This is a termination of tenancy, so just looking for a move update.
All right, this is not. Defendant failed to appear. Default judgment is granted. This is, as stated, it's a termination of tenancy, whereas all occupants must vacate by June 5th, 2023, or a writ of eviction may issue. That's case number 254. Is Sheila Phillips here? Calling case number 2334-6711, Barrow Property Management versus Sheila Phillips.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
Is Sheila Phillips here? Defendant failed to appear twice. Counsel, what are you requesting from the court?
Yes, sir, the court to enter a default judgment, please, Your Honor. Total is $4,715.
All right, and that amount at $4,715 must be paid by June 5th, 2023, or a writ of eviction issued sometime thereafter. All right. Does that conclude your docket, Attorney Horka?
Judge, I had a couple you set to the side with Attorney Johnson and Malmonius. Those are ready for the call.
Okay. All right. Let me get Attorney Doyle and Devlin. These onesies out. It's one case, and then I see a case with Johnson and a case with Lamonius, as you stated. So, and then Mr. Juan, we'll come back to you and Ms. Williamson as well. So, Attorney Doyle. Has any defendant showed up on your matter? You know that all occupants, so that doesn't help you.
No, Your Honor.
Okay. Calling case number 2334-2876. This is ANA Rental Pros LLC versus all occupants at 20170 Carey Street.
Good afternoon, Your Honor. Dan Doyle, P73181, appearing on behalf of the plaintiff, Your Honor.
Thank you, Mr. Doyle. Does anyone occupy the property at 20170 Carey Street in the city of Detroit? Counsel, it doesn't appear that anyone is here for that case. Do you have any requests for the court?
Yes, Your Honor, this matter is a termination of tenancy, so we were asking for a move-out date of June 5th, default, by default.
Okay, default judgment is granted. As stated, the termination of tenancy for all occupants must vacate on or before June 5th, 2023. The following business day, parties, plaintiff through his counsel may apply for a ratification.
Thank you, Your Honor.
All right. You're welcome. Have a great day. And Attorney Devlin,
Yes, Your Honor.
how can I assist?
Well, I was recalled to your Zoom by Sabree, who said that a tenant appeared from this morning on a case that seems to have been messed up a little bit between when the complaint was filed and when the notice was given out. So we have negotiated and reached an agreement.
So was there a different name on the complaint?
Your Honor, somehow on the complaint, the address is listed as 3053 Seaburn, but on the notice to appear I received for today, it was listed as 3065 Parker. So I've got an amended complaint to bring it back to the proper address, and then I've got a consent judgment with Ms. Braley to give her until the 26th of June to vacate.
Okay, and this is case 23347-176.
Correct, Your Honor.
Okay, all right. So we'll call it 23347-176. This was previously called. There are some clerical errors on this case as it relates to the proper address. Parties, well, go ahead, put your appearance on the record again.
Your Honor, Adam Devlin, P 72877 for the plaintiff.
This is Hillary Greeley, P number 82889, here on behalf of Kylie Ragland, who is here with us by telephone. Ms. Ragland, state your name for the record, please.
Kylie Ragland.
Thank you. This was filed against all occupants, and we certainly don't want to change that. And I was agreeing with everything that Attorney Devlin said as far as the consent judgment against all occupants with a move-out date of June 26th.
Okay, we're gonna do a consent judgment as to all occupants with the move-out date of June 26th?
Yes, Your Honor.
Yes, that's Monday.
Okay. So June 26, 2023. And we're going to, for the record, allow plaintiff to amend the complaint to show
Back
the
to
proper
original address.
Which is that for the original address?
Back to the original address.
Correct. So did I miss anything?
I just note for the record that the original address was the service address, so there's not like there's any type of service defect.
Okay, so parties were served and
Yes.
parties were here today, and we were able to work this out. So thank you for reappearing, Mr. Devlin. Thank you, Ms. Braley and Ms. Ragland. Pat yourself on the back for making this happen.
Okay.
I'll resubmit everything by fax.
All right. All right, thank you. Thank you all.
Okay, sounds good. And Ms. Ragland, that means you are free to leave, I believe.
Okay, thank you.
Okay, you're welcome.
Bye-bye.
Ms. Ragland. Oh. Ms. LeWine.
Yes, Your Honor, we are still here on 776, 777, 778, 779.
Yes. Are you ready for that?
Certainly.
Okay, calling case number 233-46776. This is Dorothy Williamson versus Curtis Samuels.
Thank you, Your Honor. Suzanne Stepich Lawan, P48702, Michigan Legal Services, on behalf of the defendant Curtis Samuels, who is here in the courtroom. Mr. Samuels, can you state your name for the record, please? Well, it looks like he's connecting to audio. Are you able to? Can you hear us, Mr. Samuels?
Let's see. Hold on, Mr. Samuels, don't.
It
panic.
looks like
It seems like he can hear us.
he can hear us, but it says he's connecting to audio. Hillary, do you have ideas?
He had issues with this morning too. There we go. Can you hear us, Mr. Samuels?
Yeah, I can hear you now. My phone had cut off. I've been on here so long. I can hear you now.
Will you state your name for the record, please?
Curtis Samuels.
Thank you.
All
Your
right,
Honor.
and- Yep,
Dorothy
sure.
Williamson.
Thank you, Ms. Williamson. Okay.
Your Honor.
Go ahead. No, go ahead.
I would move to dismiss this case. We did a deed search, and according to the Register of Deeds, Ms. Williamson is not on the deed for the property that involved the suit.
Your Honor, that is not true. That is not true. That is not true. You couldn't have done a deed search because I am on the deed, darling. And I came down to the 36th District Court and I presented, look, the judge before you, where I was, the last court case, I was advised to put the deed on record. The deed is on record.
Your Honor, I had our staff in the housing department run a deed search, and on 1610 East Warren, the names on the deed, as of today, that's not to say it hasn't shown up, but as of today, it's Vasily Shibanoff and Jason, I'm sorry, Vasily Shibanoff.
What was the address, Ms. Lawan?
16710 East Warren.
Okay. Okay. I mean, I just wanted to make sure. Okay, I just wanted to make sure you didn't say 1610. That's all. Go ahead.
And if I did, I apologize. It's been a long day, but it's showing the name of Vasily Shibanoff.
And that it will.
Carolyn,
and that is it's Vasily Shabanov. It's Vasily Shabanov, and that it will. I put this deed here, which says Dorothy Williamson here. I put this deed here. Do I have it up? We just recorded this, darling. So but you know it takes a 45 day. No, I'm talking. I gave you the time. I'm talking. This take, you know, the time period that this takes from April the 1st until now. If Your Honor, what I did was I came down just as the judge instructed me.
Oh, your audio is, I think you covered up your microphone somehow. Try it again.
Can you hear me now?
Yeah. Yes,
Can you hear me now? Just as Judge Kennedy instructed me, I came down to the 36th District Court and I put my deed on file with you. Yes, if she go and do the search right now, because we just recorded it, you can see this date. Can you see this date?
They did a search. Yeah, but she just did it.
But I put this on record. This is on file. Your Honor, maybe you can go in the system because Judge Kennedy asked me to put it on file there. I did that.
I'm looking, I'm trying to find it as we speak.
Thank you. And Your Honor, I've never been his landlord. This is no landlord tenant.
Yeah.
That's clear, Mr. Samuel. I've never been your landlord.
You never was my landlord. That goes to prove
Mr. Samuel, you'll have your chance to speak, sir.
All right, so.
Interesting.
Ms. Lamont, have you seen the deed that's in her hand?
I'm sorry, I can't see it from.
Can you take a
Did
picture
I
of?
email it to you real quick?
Yeah, absolutely.
You could, I will chat you my email address.
Yeah, I want to do it right now so you can see. It'll be
I
recorded. It's within the 45-day period, but you'll see it. It's mine. It's mine, Miss Lauren.
Then I'll recall this. I'll recall
Your
it.
Honor, there are other issues. No, I'm using.
Okay, what are the other issues?
Let me type my email address. The other issues is this is claimed to be a case for termination because of a health hazard. And she's basically said that it's due to illegal possession, which is not a health hazard, and no running water and no electricity. From the testimony of my client, as well as the gentleman who this property was at one point under land contract to, Ms. Williams turned off the electricity and the water, and these allegations of stealing light, Mr. Samuels was borrowing a generator and running a generator from outside for
There's
electricity.
no generator there.
And Your Honor, I would ask that with these issues, we're going to need an evidentiary hearing and some time to put this together.
I'm getting ready to send this to you now.
Thank you. But she's claimed this is a health hazard, and this is not a health hazard.
You know why? Because this is commercial property. This is a commercial building. So I was advised that yes, it is from the city of Detroit, that this is a health hazard. Him being there in the commercial property, this was the city of Detroit that spoke that to me. And I'm not his landlord tenant. He's squatting there. He's squatting. I was advised to put this in under a hazard by the city of Detroit. Everything I've been doing has been by the city. Can I send you this? Let's get this to you real quick.
And Ms. Williams,
no, come on now. Let me get this to you. You
interrupted with me first.
I want to get this to you. This will tell a different story. Can we do that? Can we do that?
Your Honor, I believe that this is an inappropriate claim. I believe that this
claim because Mrs. Curtis Samuels, how are you supplying electricity to your property, to that property?
With my generator.
Under whose name?
Because when I leave, I put it inside the house. It'd be stupid for me to leave it outside.
That's not true.
And I've got the same address for the last 5 years there. I got that.
And the power is on in my name. Is the whose name is the power on
in your name?
Excuse me?
You had it turned on in your name.
It's my property. If she let me send this to her, you guys will see.
You stole it from the man that had it first.
Mr. Samuels, hold on a second. Ms. Williamson, I sent you my email in the chat. If you want to email it to me, you are more than welcome to. All I know is that I had our department do a search and there was no
right now.
All right, but she's gonna email you that. So look at that before we readdress it, because it's possible that it didn't get entered into the register of deeds. It's a possibility. It looks like it was stamped. And
I'll read it. Just send it to her so she can see
so,
it.
Mr. Samuels.
Yes, sir.
How is it that you occupy 4 units?
I don't occupy 4 units. I got 4 units with stuff in it. They belong to my landlord and me.
Your Honor, if I might clarify.
Everybody moved out once they got locked out. That's why.
Hold on 1 second. So, Mr. Samuels, are you utilizing all? You just stated you're not utilizing all 4 units.
No, because it got other stuff in it that belonged to my landlord. That's why I was staying there to watch all this stuff. I have my stuff downstairs. I got stuff all over that room.
I might be.
Go ahead,
I
go
might be
ahead.
able to clarify this a little bit. I might be able to clarify this a little bit. So it's my understanding that this property at one point was under a land contract from the name that I cannot pronounce, and I apologize for that.
Do you have a copy of that contract?
Not yet, because I just met Mr. Samuels and Mr. Kemp, and they were having technical difficulties. But apparently Mr. Kemp had a land contract at one point with Vasily Shibanov. And this is going back several years. At that point, Ms. Williams and her husband were renting a property next door that was also owned by Vasily Shibanov, who, again, the deed shows up as that. There was some default at some point on the land contract, but no foreclosure was ever filed against Mr. Kemp, who was the payor on the land contract, the purchaser. At that, soon after that, or just prior to that, he had been involved in an accident or had some health issue. And at that point, he asked Mr. Samuels to please move into the building because it is the building that's 1610 or 16710. Sorry, I just got the deed. Because that property was a storage area on the bottom and 4 apartments on the top. There were some issues with prior landlords. Ms. Williams locked everyone out of the building at one point. So the tenants
How do you know that to be the case?
Because I spoke with Mr. Kemp, who was on the call with Mr. Samuels. And according to them, they were all locked out of the property, so they couldn't get their belongings. Mr. Samuels and Mr. Kemp had been trying to make improvements to the apartment units, including some repairs from a previous fire. And so they have materials such as drywall and doors and windows stored in the 3 other units that were intended to make the repairs on that unit. Mr. Samuels lives in one, but there is property of Mr. Samuels and Mr. Kemp in the other 3 units.
All right, okay. So Mr. Samuels, what unit do you live in?
I live in 1A.
All right. And where do you have the least amount of property?
Where I have the least amount?
Yeah.
Probably in the other couple of apartments. There's not much, but most of the stuff belongs to Mr. Kemp.
All right.
Do you need to talk to Mr. Kemp?
Mr. Kemp's not a party to this case. No. No, I do not need to talk to Mr. Kemp. He is not an occupant or a defendant. All right. I'm willing to dismiss 2 of these cases with an order saying, with further notices saying that Ms. Williams is entitled to full use of her property. Why shouldn't I do this?
I would just ask, Your Honor, that they have time to remove the materials that were intended to improve the property when they were working on it. And I still claim too that this was improperly filed. This was filed as a health hazard. She's not shown a health hazard that
it's a dismissal. So it's not the result but a dismissal.
Okay, you're right. But I would ask that if we dismiss the cases and we tell Ms. Williamson that she has right to possession, she give Mr. Samuels opportunity to remove his possessions that are being stored in those other units.
How much time does Mr. Samuels need?
He'll need time to rent a storage unit and remove the property. Apparently it's building materials and large materials, so I would say 30 days would be plenty for them to make arrangements for that.
Mr. Samuels, how much time do you need?
30 days be good.
Need 30 days to move the materials from upstairs to downstairs?
If we can get in the building.
They've used the storage area on the first floor. Apparently the first floor is a storage area and the second floor is 4 rental units, 4 apartments. And they have been locked out of the storage area where they had kept some of the materials as well.
Your Honor, he's not locked out. They have keys.
Hell, I'm locked out. Y'all done changed the lock.
Okay.
Okay,
You
what?
done? Are
Yeah,
you done? You've been angry and I've been trying to talk with you for the longest. You're angry.
All right, so this is what we'll do.
He's threatening to burn the building down. He's angry. You guys really don't know, the threats that he's opposing. I have to put in police reports, because of how he is. He threatened, that he's gonna burn the building.
I object, Your Honor. She's provided no evidence of police reports or anything else.
He's under oath. Ask him, did he say that? He's under oath. Ask him. He's under oath. He's angry. I don't want to be angry with him.
He's clearly angry.
He is. He's been like this though. He calls the police on us.
This is what I'm gonna do. This is what I'm gonna do. For units, what's this? 1A. Let me unmute him. Mr. Samuel.
Yeah, I'm here.
Which unit access to? You're in 1A. What else? Do you have access to 2A?
No, I do not.
You have access to 2B?
Yeah, I can get into 2B.
Okay, what about unit 1B?
Yeah, I can get in there. That's straight to my upstairs back door.
Okay, 1A and 1B.
Yeah, so downstairs that they don't change the lock on.
Okay, so you can't get into 2A. That's the only unit you can't get
No,
into?
that's downstairs where all my other stuff is. My storage area. That's a whole new different apartment section. A different building. It's 2 buildings, a mechanic building, an apartment, and the storage.
And this case, Your Honor, doesn't involve the mechanic shop, I don't believe. That is at 16700 East Warren.
Yeah.
And I don't believe that this case involves that building, at least not what I've seen.
16710. So I'm going to dismiss. Which units can you clean out, Mr. Samuels?
1A.
I thought that's where you were living.
That's where I'm living. I gotta clean that out too if I got to move.
Right, but within the next, I'm gonna order a dismissal on 2 out of the 4 cases and order that you have 2 units, that you allow her use of 2 units to do whatever she needs to do, and then we'll adjudicate the rest.
Right, so but I still can't get downstairs to all my other stuff.
All right, so what do you suggest?
The other
I can get my
stuff.
stuff out of there.
Do you mean get Mr. Kemp's stuff out of there? Because
That's
that's
my
not
stuff
your
too. I
stuff.
work
That's
with
Mr.
Mr.
Kemp's stuff.
Your Honor, it seems that Mr. Samuels and Mr. Kemp have worked together for a long time and have accumulated joint things. And so their items are commingled.
Okay,
But
well,
Mr. Samuels maintains that he has stuff in the downstairs storage area.
I've been my landlord for 12 years. So how the world she gonna come in? She just come in the last 2 or 3 years.
Okay, all right.
Yes,
Well,
sir. I've been with him almost 12 years.
Your Honor, I will rent a U-Haul if they need the help for that. I'm more than
I
capable
don't need you to
of
do nothing for me.
renting.
Just let me get my stuff. That's all you need to
Mr.
read.
Samuels, let Ms. Williamson speak.
I don't want to be angry with him. If I can help him just so that I can move on, because I have other partners that are, coming in with this project with me, but I will rent them a U-Haul. I will do that. I'll even try and help pay to help him get, because there's probably are heavier things there, and help get that to wherever they want to get it to. But I don't want the animosity between them. It's been like that.
So, all right, you are not a party to the case. Please state your name for the record, because you spoke on the record. Who are you, sir?
You have to unmute.
Yeah, upset.
And remember that you're talking to the court. Remember that you're talking to the court before you unmute with all that hand gesturing. And please remove your hat.
Okay. I have rented the property.
Mr. Kemp.
What is your name? What is your name?
My name is Michael Kemp.
All right. Do you swear to tell the truth and nothing but the truth, Mr. Kemp?
I don't have any problem about telling the truth.
The truth and nothing but the truth. Yes or no?
Yes, I tell the truth all the time. I'm a pastor. I'm Reverend Kemp. You want to know who I am? My son is Solomon Kemlock. I don't have.
All right, Mr. Samuels. I asked you a yes or no question, and you telling me that your son is Solomon Kemlock, which is I know Jonathan and Chantella, and and Solomon. I know all of them. So I'm going to unmute you and ask you, do you swear to tell the truth and nothing but the truth? All right. Okay, this is what I'm going to do. I'm going to dismiss case number ending in 2334-6777, 2334-6778. We'll maintain the lawsuits on 2334-6776 and 2334-6779. And those cases that we're maintaining is unit 1A and 1B. Ms. Williamson, I know you have to go back. You don't have your schedule is a little strict, so we'll adjourn these two. I'll let you and Ms. Lewan sort out whatever issues you have. If they're title issues, they're going to be sorted out beyond my courtroom anyway. So if cases need to be filed, I can't stop you all from filing any actions for land contract or, not land contract, but any actions for possessory interest in the land. But as for 2334-6777 and 2334-6778,
Your Honor.
This 2A.
Your Honor, can I say one thing? I only want to say one thing and I'm done.
So unit 2A, 2B, these matters are dismissed and defendants have 14 days to relinquish the possession to Ms. Williamson so that she can utilize those properties. If there is a title issue.
Can I get into the bottom of the building? That's the only thing I'm asking for.
Still, I'm asking for my yes or no question that you never answered.
I said yes. If you could have heard me.
You can get in 1A and 1B. Obviously, you can get in 2A and 2B. You all have 14 days, sir.
I can't get in the bottom half because of
Mr. Kemp.
Oh.
Your Honor, what I think we are losing in the communication, this is a 2-level building. They can access the top level where the residential units are. Below that, there is a storage area that they cannot access. And that's the part they're arguing about.
And is that 1A or 1B?
It's not any of those units. It's another part of the building that they have used.
I don't know what to say over it.
But when they gained possession of the building in 2014 or before that, they had that as their storage unit. And that was
Okay.
part of the building. That's part of the building. It's just not one of the residential units. Excuse me. In addition, Your Honor.
So, Ms. Williamson,
Yes, Your Honor.
is there, I mean, can they reasonably move their stuff without access to the storage unit?
Yes, they can.
Well, they can remove the stuff except the stuff that's in the storage unit.
Okay.
Well, whatever they want to move, whatever that he's, you know, he's more than welcome to come and move it. And like I said, if they need me to help them get the U-Haul, I don't know if they can get, he's upset. They upset. I don't want to be upset with them.
But Your Honor, if I might
help them if they need it.
And that's very kind and very appreciative, but I still object that this was not filed properly. It's filed as a health hazard, and she's shown no health hazard.
The health hazard is that he's living in a building without any electricity or running water, and that causes
which was turned off by the plaintiff, and he does have electricity because it's a he has a generator, and in order
the creeps in some carbon monoxide, they're dead.
Yeah.
But the generator's outside.
Well,
he said the generator is outside while he uses it. And he said that on the record too. There's a question of fact here. The standard for a health hazard eviction is when the person in possession willfully or negligently causes a serious and continuing health hazard to exist on the premises. And she hasn't shown that he's doing that. He's not.
Most habitable places have electricity and running water.
Yes.
Correct. I'm sorry. I am so sorry, Your Honor.
No, it's fine. Obviously I just cut you off. Come on.
But the statute says that the tenant had to cause that, and the tenant didn't cause that. It was turned off by the plaintiff, and that would be considered a constructive eviction. And she could be charged with penalties for that.
DTE told us who turned it off.
I just want to get my stuff out of there. I don't want the building. Do you understand something? If I get my stuff out, I'll be
Do you understand? Do you understand who you talking to right now? Mr. I don't know who your name is. I don't know who you are. Mr. Kemp. Mr. Kemp. You're in court right now. I've made an order. I've made a judgment. You may retrieve your items for 14 days. You have to allow her use of unit 2A and 2B. We'll be back in a month. We'll be back in a month to address 1A and 1B. And in the meantime, in this period, this 2-week period, that probably will extend a little further than 2 weeks, but this 2-week period, you're gonna have access because she's allowing you to move your stuff out. And this is the order of the court. So if you don't, you come back to me and say you don't have access. And I'm gonna ask Ms. Williamson to allow you access. That's it. So we'll be back. Let's pick a date. Today is May 25th. Let's come back. June 22nd. Is it? Attorney Lawan, is that?
I'm looking at that should work.
Ms. Williamson?
Yes, just need a date so I can, give it to him. And like I said, if you need assistance, I'm willing to give it.
Okay, let's go June 22nd at 9:30.
Is that a return date to court?
That's a return date to court for, and then the other two matters are being dismissed. Matter 7-7, so 1B, 2A and 2B will still be at issue. So June
I'm sorry,
22nd.
sir. I'm
No,
sorry,
go
sir.
ahead.
I'll be on vacation from the 18th through the 23rd. I'm sorry. That's my vacation from work.
All right, that's fine. All right, well, June. What's better for you, Attorney Luan? Was it Tuesdays and Mondays, Wednesdays, Thursdays?
Those are our court dates, yes. So
Okay.
one of those would be better.
What about June 28th?
Sounds great.
For me.
June 28th
9:30 a.m.
at 9:30 a.m. Now, I'm confident that parties can work this out. So I will be back June 28th at 9:30 a.m. So you are to allow for them to remove their property in those units, and plaintiff will be entitled to possession to those units. And then for those other two, you're still occupying the other two, so we'll sort that out. And if there are any title issues, that will cover the whole address anyway. So,
Well, Your Honor, how will I get in touch with them as far as to allow, you said 14 days to allow them to, get their things out?
Attorney Luan.
Okay.
I will send you an email that has all my contact information on it.
Okay, thank you.
All right, okay, parties, good luck. This is, we'll be back on the 28th. And in the meantime, just stay civil. Mr. Kemp, Mr. Samuels, you all just work it out, all right? I'll have a great day.
Thank you, Your Honor. Mr. Samuels, I will give you a call later, okay? I'll give you a call. But you're free to go from Zoom.
All right. Okay. We have, this is the, oh man, we still have Transasha Washington. All right. We're ready for the next two matters. Calling case number 2334-7262, Staples Property Management versus Transasha Washington.
This is she.
Afternoon, Your Honor. Joe Horka, P75969 for Staples.
Good afternoon, Your Honor. Michelle Johnson, P49181 with Legal Aid and Defender Association on behalf of Ms. Washington, who's in the Zoom courtroom.
Thank you. Can you state your name, Ms. Washington?
Transasha Washington.
All right, thank you, Ms. Washington. The parties able to work out an agreement on this one?
No, Your Honor. I'm sorry. No, Your Honor, we haven't worked out an agreement. We did have some discussions. There are some issues with the ledger that counsel needs to clarify, and so we would ask the court for an adjournment.
Okay, how far out?
My preference would be to keep it here on Zoom before we go, but whatever the court can accommodate or Attorney Johnson's request.
Okay. All right, how about
Maybe next Thursday?
Was that June 1st?
Yeah, I should be able to do June 1st. I'm gonna be out of the office at an event all day on that Friday, and I know that we go back in person on the 6th. So, but yes, we could do the 1st. Would that work for you, Ms. Washington?
No, June 1st is my son's graduation.
Is there a time during that day or can we do it early in the morning? I'm thinking that we might be able to have it resolved based on our conversation earlier.
I don't want.
The other option is that we will have to, well, Judge, if you need to put it in person, then that's fine.
I'd rather put it in person and disrupt the graduation. It's up to you. It's either, yeah.
That's fine. Which day would it be, Judge?
It'll be that June 5th. Go Friday. Oh, no.
Fine.
You said, no, you can't do Friday, Ms. Johnson.
Yeah, no, I'm gonna be out of the office on Friday.
Okay, let's do June 6th. Maybe it's
Okay.
a little chaotic.
Okay. So my kindergarten is graduating the 6th.
All right.
How about the 7th? I'm honestly thinking, Judge, that we probably can get, as long as we get the ledger clarified, we can probably get it resolved with a conditional dismissal. That's my expectation.
No, it's fine. I'm okay with it. June 7th is fine. It's graduation time.
That'll work.
Okay, what time, Your Honor?
Let's go 9 a.m.
June 7th, 9 a.m.
Yes, ma'am.
Okay, that's fine with me.
All right, I'll see you on June 7th.
Thank you,
Okay.
Judge.
Thank you.
You're welcome. All right. Okay.
I'm good to go.
You are good to go.
Thank you. Have a good day.
You're welcome. You too. Tell the kids congratulations.
Thank you. You heard that, DeAndre? He said congratulations. Thank you. Bye.
Bye-bye. Okay. Calling case number. Hello. Calling case number 2334-6705, Investors Property Management versus Catherine Baker in all occupants.
Good afternoon, Joe Horka, P75969 on behalf of the plaintiff.
And good afternoon, Lauren Lamonius, PA3053 on behalf of Ms. Baker.
Thank you.
Your Honor, I believe we are really close to a resolution, and it's my understanding that we would like to come back and maybe even have a control date, or maybe not, but next week on Thursday, June 1st.
Okay. I can do June 1st. What,
Yes.
10 o'clock?
Yes. 7.
That works for me.
I'll see you all back June 1st at 10 a.m.
Thank you. I do want to make sure that works for Mr. Horka.
Oh yeah, I'm here every day. That'll work.
Okay. Thank you.
All right.
And Mr. Horka, could I join you in a breakout room really briefly or not? Okay, thank you.
All right, you all have a great day. I'll leave it open for a while.
I did have a land out case at 1:30.
Did you? Okay. Oh. You have a land out case at 1:30 in there?
See anything?
Have one.
Powers versus Bolden.
No, I just have a 876. Attorney Doyle was my only. Give me the case number. I want to make sure that a little funky today. Have these ghost cases.
I have to look it up myself.
Maybe I'll leave the breakout room. I mean, I'm leaving the, well, yeah, look it up. Take your time, man.
And I think it's actually scheduled on June 1st at 1:30. So Mr. Lando's just calendaring was wrong. So I think I'm all set.
Okay, all right, have a good day.
Thanks.
Let me say.
Oh.
Was that it for today?
That is it for today. Thank you all for your zealous advocacy today.
It was super fun. We're still on
Leave
YouTube.
me
by
with
the
all
way.
the fun ones.